Good morning, everybody. Happy Friday Eve. It's a Thursday here at TCF Live. Good to have you all with us today. We'll start with Judge Middleton. He's doing misdemeanor arraignments on this fine, undoubtedly cold Michigan morning.
Crappy hard. I had two guesses, and I got it wrong last time, too.
It's okay.
You met with village attorney for Constantine, Mr. Howard Bush. He tells me you have your license and you're good. They're going to dismiss there's no valid operator's license, and you're going to enter a plea to a charge known as allowing another to violate the motor vehicle code. That's what usually happens with these. The lawyers, the prosecutors, and the court try to work with people to help them get their license back and get off the driving suspended merry-go-round. If you'd gotten a no ops, you wouldn't have been able to get your license that you have now. So Mr. Bush and the court adjourned this to let you get your license, and you held up your end of the deal. You got your license. So he's amended it to a charge called allowing another to violate the motor vehicle code. That doesn't carry any points. It doesn't get abstracted to your driving record and should not affect your ability to keep or maintain your driver's license. However, it is a misdemeanor, even if it's a very minor one, punishable by up to 90 days in jail and a fine of up to $100. Normal fine for this is $200. Do you understand?
Yes, sir.
Other than what I just said here, did anybody promise you anything to get you to plead to
No,
this?
sir.
Or promise or threaten you?
No, sir.
To understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will not be a trial.
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. If you wish to have an attorney, all you got to do is tell me, and I could appoint one for you like I did for the last two gentlemen. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Understand?
Yes, sir.
All right. Were you driving a car in Constantine back in October of 2025 and your license was not valid at that time?
Yes, sir.
It had been, I'm not sure what happened, but you were eligible to get it reinstated in January, and you went to the SOS and did get it reinstated?
Yes, sir.
Very good. All right, I'm gonna do a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. That's $200. Can you pay that today, or do you need time to pay it?
I need time.
I'm gonna give you 30 days,
Thank you.
which will go to February 27. The only people that pay are the Mexicans and the Amish people. Everybody else asks for time, but they do mostly pay. This will be by 2/27/26. All right, I'm glad you got your license back. This won't affect it. And going forward, you should be good to go. As long as you pay this. All right, good luck to you.
Thank you, sir.
Mr. Truckee, you've popped your collar there on the left side.
No, I lost a button.
Oh, yeah, that's
Any buttons?
I think you got it.
Thank you.
Good morning once again, everybody. Excuse me. Hoarse throat this morning. Anyways, good morning. TCF Live. It's Thursday, or as we like to call it here, Friday Eve. It's good to have you all with us. Let's Go to Judge Dad, see what's going on there.
Good morning, counsel.
Good morning, Your Honor. Tim Gambler, P78192 on behalf of Mr. Giles is also present.
Your name, sir? So as I understand it, he's going to plead guilty to 2 counts of disorderly.
One count.
1 count? Why a no contest plea?
Uh,
Call in Mr. Bologna, John.
Okay.
249, I believe it would be. What's the basis for the no contest plea? Was there?
there's gonna be continuing legal action, Your Honor. The condition that he's in right now was a result of what happened during the incident. So the no contest plea, I believe, contemplates future litigation.
All right, let me get the prosecutor in here. I just need him to clarify something. Mr. Bologna, your appearance?
Getting going with the city attorney, Your Honor.
Good morning.
Morning.
I just want to clarify, it's 1 count of disorderly, right?
There was an A and a B.
I know, and you got disorderly and
Yeah, 1 count, yes.
which count? Do you care?
I don't care.
Why don't you just write on here, if you don't care, count 1 or count 2, and I'll take the plea on that one. And the reason for the no contest plea, was there actually an allegation, counsel, of, in other words, is there a possibility of civil litigation on this, Mr. Bologna?
Yes, Your Honor.
Let me just double check. I would think in an assault case, but I want to double check something here. Do you have the police report in here for me?
I have it right here, Your Honor, if you'd like to look at it.
Yeah, I'm gonna need to have that marked.
That, bro.
Yes, you can add it to my recorder there.
I have it as part of the discovery package.
Wait 1 second, slow down. Maybe I can just have this one marked.
I have a separate one.
Why don't you give me a separate one? If you can always bring those in on a no contest plea, it would help. So do you understand what you're doing here, Mr. Giles? You understand you plead no contest to 1 count of disorderly, which I suppose would be count 1. That's what he's written down now. That I'm going to dismiss both counts, count 1 and count 2 of assault and battery. Do you understand that? And you understand a no contest plea has the same effect as a guilty plea? You can. And you understand the possible penalties on this are up to $500 in fines, 90 days jail, costs, or all of those. Do you understand that?
Yes.
Can I have you staple this? Is this the only police?
That's it.
That is it, Your Honor.
All right. And I'm sorry, you can have that staple that market People's 1. You
Your
go,
Honor,
hang on.
if I may, there was also a body cam in this, which we attempted to get, but I believe it was protected under HIPAA. And I think the officers had indicated that they will at some point allow us to maybe look at that and redact it together, but we did try to get the police, that there was no, that we couldn't get the body cam, and also with the discovery, no witness statements and no photographs of alleged injuries. So I would just point that out.
Well, that's between, if that pertains to other litigation, that's between you and Mr. Bologna and the circuit judge, and whether or not there's issues raised of HIPAA violations or potential HIPAA violations. If I,
Point that whole story.
okay, so I've had this marked People's 1. You stipulate I can use this, Mr. Gamber
Yeah. So
and Mr. Bologna?
Yes, Your Honor.
Sir, did you sign, read, and understand an advice of rights form here today? If you plead no contest, you will be giving up all the rights on the advice of rights, and we are not going to have a hearing or a trial. Do you understand that? Any questions before I ask you how you proceed, how you wish to plead? I'm sorry?
No.
All right. To the charge of disorderly person, how do you plead?
No contest.
All right, let me review this. Are you on probation or parole? I can't hear you.
No.
And I find there's a factual basis for the plea. Has anybody forced you to plead guilty?
No.
All right, I'm gonna accept your plea to count one, disorderly, no contest. Again, I find there's a factual basis. I'm gonna dismiss count one, original charge of A and B, count two, A and B, refer you for a pre-sentence report. Didn't see anything in here about, let me just double check. I didn't see anything that he was under the influence, so I'm just going to order a PSI. We'll give you a sentence date. He's going to undergo a PSI today. We're going to notify the victim, Amy.
We can do the 12th, February 12th at 8:30.
That's good with me. You good, counsel?
That's awesome. That's great.
February 12th at 8:30, sir. We'll see you back here. Thank you.
Thank you.
Thanks, Mr. Ronya. Thank you. Bill and Lane Haynes, 260-647-075, and I'd like Celia Renee Pixley Zakowski seated at this table. My right, your left. Come on up to the podium, Mr. Haynes. Tell me your name.
Dylan Haynes.
You're charged with drive while unregistered vehicle. You have the right to a lawyer. Would you like a lawyer?
Sir. Sir.
Okay, you go out in the hallway, we'll give you a lawyer. Okay? Celia Renee Pixley Zakowski, 260-647-514, A and B. Come on up to the podium, ma'am. And tell me your name, please. This guy needs a lawyer. You're charged with expired license and also driver license, driving with an expired plate. Expired license is a misdemeanor. You have the right to a lawyer on that. If you'd like one, I'll give you one. Otherwise, I will arraign you and send you to the prosecutor. Talk. I can't hear you, ma'am. Okay, just keep your voice up nice and I'll go ahead and arraign you. On January 10 of 26, it is alleged that you did operate a motor vehicle on Fort near Freeland in Trenton at 8:39 p.m. Drive while license expired as a misdemeanor, punishable by up to $100 in fines, 90 days jail, costs, or all those in 2 points. Do you understand that? And you're also charged with expired plate. That is a civil infraction. Do you understand that? Did you sign, read, and understand the advice of rights? Did you plead guilty? You'll be giving up all those rights, and we're not going to have a trial. Do you understand that? All right. You still wish to waive your right to a lawyer? I'll enter a not guilty plea, $100 personal bond. You don't have to post any money. You have to comply with these bond conditions, though. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You go outside, the prosecutor will call you. We're going to bring this file to the prosecutor, and then once you talk to the prosecutor, you'll come back in here. Okay? Thank you. Francisco Elijah Cantu, 25F2447628.
Good morning, Your Honor. Mr. Chairman, if I can.
All right. Mr. Cantu, your name?
Francisco Cantu.
All right. So your client, Mr. Shemke, pled no contest operating while visibly impaired. There was an accident here. He was referred for a screening and assessment. But before you go on, I need to make sure, Amy, that there's not a Timothy Roberts out there, either in the courtroom or on Zoom. He was notified he is the victim. Anybody out there?
There is no Timothy Roberts on Zoom.
Thank you. Have you had a chance to review the report, counsel, and are there any material additions, corrections, or deletions?
I have, Your Honor. It's factually accurate.
Anything you'd like to say on his behalf?
Yes, Your Honor. My client's done extremely well on bond. Still had gainful employment. I looked at terms and conditions. I do believe they are appropriate. I believe he could put himself in a very favorable position for early termination. That being said, Judge, he works somewhere between 55 and 65 hours a week and more. I potentially just ask consideration for as an alternative to the workforce for community service. But otherwise, I believe all those conditions are appropriate and I have no further requests. Thank you, Judge.
Sir, anything that you would like to tell me before I sent you?
No, Your Honor.
And this is your first contact, but you're only 22. This kind of scares me that you're here already. I was telling you. You understand?
Yes.
Okay. All right, 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You do have to appear as directed. No alcohol. No alcohol at all. You're not to purchase, possess, or consume any. No marijuana, no illegal drugs. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs. They're recommending it appears bi-weekly throughout. I'm going to make it bi-weekly for 4 months. If you're clean, I'll make it monthly. So make sure all those tests come up negative, okay? You understand? You're to attend the substances abuse group through Class A Training Center. You're to attend the Victims Impact Panel. This does no contact with the victim at all. I'm going to order 4 days jail, credit 1, serve 3. I'll let you do one of those by way of community service, but the other 2 are going to have to be done on the court work program. 1 day community service. I'll give you until March the 15th to complete that. 2 days on the court work program. There's a $35 a day charge for that, for a total of $70 in court work program fees. So far, do you understand the sentence?
Yes.
Okay. This was a intoxilizer, correct, counsel?
Yes, Your Honor.
So I'm going to give them a cost of recovery of $150, $300 in fines, $250 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $675. Cost of recovery is $150 for 8 1/4. Screening fees $60 for 885. Probation fees are $240. So your total there amounts to $1125 plus the court work program fees. Your total is $1,195. If you violate, your probation could be revoked. You could be eligible. You could be incarcerated for up to 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Also, you may be eligible for early discharge. You stay out of trouble, no violations. You come in here in 6 months. You fill out a petition. By law, you're entitled to early discharge. Okay? You understand all that?
Yes.
All right. Does he have all this to pay, Mr. Shemke?
Do you need a payment plan? Yes, Your Honor. I'd ask that,
He can pay it all?
in this circumstance, I'd ask that, if he's eligible for early termination, his balance would be paid minus the potential extra 6 months of supervisory.
Well, we'll return that.
Okay.
Ma'am, you gotta take that phone out of here.
The phone has to leave the building, ma'am.
Ma'am.
Phone has to be out of the building.
They gave you that phone?
Yeah,
Who's they?
Who's that?
in the door.
All right.
Yeah.
We will refund that if he's granted early discharge.
Take it out.
Okay, sir, you're gonna meet with the probation department, okay? Go down, pay your fines, and then go over to probation, and they'll instruct you.
Thank you, Judge.
Thanks a lot. Have a good day. Holly Darnell. Holly Ann Darnell, 25T647138.
Good morning.
Good morning. Your name? So you owe 185. You need time to pay.
Yes,
Do you have anything today?
I have 45 on me right now.
Okay, when can you pay this?
Can I pay a little bit the following Friday and then the rest of it the following Friday?
Sure. How much can you pay on each? I'll tell you what, you pay 45 today. You pay the balance at rate of $50 per week. I'll give you a little extra time, 50 per week, and we'll start that on February the 6th. Is that good?
I appreciate it.
We'll make it February 9th so you can get it here. If you need more time somehow, no worries. Come talk to me on or before the due date, or call the court. Tell them we need to go on Zoom. I'll go on Zoom with you. I'll grant you an extension on or before any due date. I don't care how many
Oh,
times.
thank you. I appreciate it. Times are hard right now.
You know how many people take me up on that, though? They say thank you, and then they don't call instead of, so I don't care if we have to do, I'm just telling you, I don't care how many times we have to do it, all right?
I do appreciate it.
Good luck to you. Thank you.
Thank you.
Mark Daniel Purdy, 25T 645-104. Mr. Purdy, come on up here, sir. Your name?
Mark Purdy.
All right. Illegal firearm transport is the charge. You have the right to an attorney. If you would like one, I will give you one. Would you like an attorney? I'll go ahead and arraign you on January 9 to 26 at 8:39 in the morning. The police think that you were on Medford near Belmont and Trenton and that you illegally transported a firearm. It says defendant was located inside his vehicle with two pistols in his center console, unloaded, but with one magazine loaded in the center console and another in the glove box. That is a misdemeanor. And your CPL, they say, expired in 2018. That is a misdemeanor under local ordinance, punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form?
Yeah.
If you plead guilty at any time, you will be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yes.
Not guilty, pleas entered. I'm going to give you a personal bond of $500. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You're not to possess any firearms. No firearms. You're not to possess any firearms. If you have any, you have to surrender those to the police department, Trenton, within 24 hours. And you were printed on this, and also no contact with prosecution witnesses except through your lawyer. Do you understand all that?
Yeah.
All right, so go talk to him. And I'm going to put this on here. Or you're going to wait outside in the hall, and the prosecutor will call you, and he's ready to see you, and then you can come. You're going to come back in front of me either way. Okay. Good luck. People against Alan Fonseca. Which ones do you have?
I have the sensing on Collins.
I'll call that next. Alan Fonseca. See here?
No,
Lynn
Judge,
Fon-
sorry.
Go ahead. I'm sorry.
The police department just wanted to dismiss that one, so I pulled it.
So the prosecutor wrote up this failure to respond to civil infraction. He sent it in. I can't read what he said, 5 pond or something like that. But at any rate, he's moving for dismissal. Case is dismissed. That's again for failure to appear for a civil infraction. People against Collins, Devin Tyler Collins, 25B149-7738. Good morning, Mr. Schwab.
30720, if you have Mr. Collins.
I also have a B file here. He pled under 7411. That is a possession of a controlled substance, which is cocaine. And he also pled on the drunk driving to the charge of operating while visibly impaired. He was referred for a screening and assessment. Have you had a chance to review that with him? And are there any material additions, corrections, or deletions?
Chance to review with him. I thought that the drug case was marijuana.
Wait a minute. No, I don't think so.
I know he.
They found it prints out possession use of a controlled substance, but this is the one where he acknowledged to the police that he had cocaine in his pocket.
Well, I wasn't the original attorney.
Am I right or am I wrong, sir?
You're correct.
Did I ask you your name yet?
No, thanks, Devin.
Okay, so it was the cocaine. And he was referred for a screening and assessment. Have you had a chance to review the
I have your honor.
report? Any material additions, corrections, or
He
deletions?
would speak back to the editor.
Okay. Anything that you would like to say on his behalf?
Just your honor, that I believe that he has tried to address the problem. He's gone to AA meetings. He has abstained from any alcohol and drug usage. He's a working man. It's a little light working during the winter time. He does catch some things.
Okay.
And so
He's spending all his money on cocaine, though. What's he doing? Go ahead. I'm sorry.
I think that he's right now he's saving a lot of money because he's not doing it.
Well, that's good. That's good. Mr. Collins,
Yes,
what would you like to say? Anything?
Not really, just I apologize for my.
Don't apologize to me, apologize to yourself. You know what I mean? You're a nice looking kid. You seem to have a lot going for you. Get away from that stuff. And the marijuana too, right? I mean, come on. Don't do this to yourself. I hate to see kids like you or anybody, frankly, get themselves in trouble. You just seem like you got a lot going for you, and that cocaine is miserable stuff. Did I let you finish? I'm glad to listen to anything else that you'd like to say.
I do have my 2-month coin from AA. I've
Fantastic.
been going 3 times a week. Basically, ever since the arrest, I've been mostly clean as a whistle, basically up until about 2 months ago. So
Wait a minute, Chase. Say that again. The offense was in October. We didn't have a pretrial on this till December 18th. What do you mean? I thought I heard you say I was clean as a whistle up until 2 months ago.
yeah, after the arrest, about I was still smoking a little bit, and
I see.
then after about 2 months ago, I was going to stop altogether.
All right. You have proof of your AA attendance? Can I see it?
There's 2 separate ones because I misplaced one of them. So there's a couple on, there's mostly on one of them and a couple on another.
All right. Who do you live with?
Myself.
You own a house? You rent a house?
I live at my grandma's old house and paying off her mortgage right now. I'm living there.
Hey, don't lose these anymore. I'll take it your word. I'm gonna hand you these back. Can you approach Mr. Schlaffel, hand those back to him?
Yeah.
And he's going to stay out of trouble. I know he is. Right, Mr. Collins?
Yes, sir.
All right. 12 months probation. On file A, it's not under any statute. In other words, there's no 7411 or anything else, but it is on the B statute. So if you're clean, you do everything I tell you to do, that's count 2 on motion to prosecutor is going to be dismissed. Because I'm taking it under that statute. You understand that, right?
Yes, sir.
So 12 months probation, all these terms are going to run concurrent. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those things. I do want you submitting the chemical, kratom poppy seeds and CBD oils are prohibited, by the way. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs bi-weekly. The cocaine has me even more concerned than the other. You're going to do that for 5 months. If you're clean, I'll then make it monthly. So every other week, you're going to test, and I expect you to test, okay? We want to make sure you stay off of that. You understand?
Yeah.
All right. 4 days jail, credit 1, serve 3. I'll let you serve all of those on the court work program. There's a $35 a day charge for that for a total of $105. Again, I'm attributing the fines and costs primarily, unless they say otherwise, and all the common costs on file A. So you're also to attend and complete an outpatient substance abuse treatment program. You're going to continue going to AANA 3 times a week until you're in until you're in outpatient treatment. And you are also to attend the victims impact panel. So the quicker you get in outpatient, the better. If you get in this week, you no longer have to go to AA or NA, but you do have to complete outpatient treatment. You do have to attend the victims impact panel. Do you understand everything I've said so far?
Yes.
All right. In terms of fines and costs, on the A file, the impaired file, $300 fines, $250 costs, $75 victims' rights fee, $50 justice assessment, $675. Screening fee is $60 for 735. Probation fees are $240 for 975. You have cost of recovery of $218 for a total of $1193. You have, I'm going to just assess $40 in attorney fees for a total of $1233, plus the court work program fees of $105 for a total of $1,338. I'll go light on your fines and costs on the other case. It's simply going to be 100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. The screening fee, probation fees, cost of recovery fees are all going on the A file. So you owe $325 plus $1338. That would be $1663. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And you may be eligible for early discharge, certainly on the impaired, and the prosecutor certainly can move to dismiss the 7411 if he is satisfied once you file your motion for early discharge on the A file.
Your Honor, if I may.
Sure.
Is it possible for him to do some extra community service in lieu of some of the costs?
You can't pay these fines? I mean,
During the winter, I work like a part-time job because my job is seasonal, so.
here's what I'm gonna do.
After the time during.
I'm gonna let you pay $50 a week. And I'm gonna do that on the A file. And I'm gonna start that beginning on February the 27th. I'll give you a little bit of leeway time. So I'm gonna only have you pay $50 per week starting that date. If you need more time, you can come talk to me. After you pay the fines on and costs on that, you're gonna pay on the B file. So after fines costs paid on the A file, you'll pay them on the B file. If you're really running into trouble, you come back in here, file a motion. I'll be glad to entertain that request for you, okay? I'll give you a review hearing date right now, which is going to be 12 months out on the 7411, the drug charge. What do you have for me there, Amy? It should be in January of 27, God willing, if we're all here, Mr. Sloth.
Very good.
It's going to take her a minute. That's the next year's calendar.
January 27, we can do the 14th.
14th is good. January 14th at 8:30 in the morning, okay?
Yes, sir.
Now, that's independent of the other case. So if you do everything, there's no violations, you feel free to make your motion for early discharge in 6 months on the impaired charge. And usually the prosecutors will then go ahead and move to dismiss on the other, okay? I wish you well. Thank you, Mr. Schlaff. You're going to meet with probation before you leave here, okay? Thank you.
Good morning once again, everybody. TCF Live. It's Thursday. I hope you're all having a good day so far. Let's switch it up. We'll stay in Michigan, but let's go see what's going on with a certain Judge Simpson who's getting his day rolling.
Come on up. Oh, somebody. I need.
Right. We're starting strong.
Yes, we are.
Your Honor, Ms. Cannon is having some stage fright. Michael Getty from the Washington County Public Defender's Office. Your Honor, to the extent that there's a conflict, we would waive any conflict. Once we agree with the prosecutor, we'd ask the court to waive any conflict or any potential conflict or thought of a conflict in these matters.
And the court, for its part, does not believe there's conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Kenyon Jackson.
Al Chavalowski for the People. David Eichelstein to bring on behalf of the defendant.
All right, Mr. Jackson, can you state your name, please?
Hey, Al Jackson.
Thank you, sir.
Your Honor, Mr. Chavalowski and I have had an opportunity to discuss these matters. This matter is going to have to be sent, these matters are going to have to be sent to circuit court for resolution. My client was unaware of that because he's in the Macomb County Jail. But Mr. Jackson, we're going to work out a deal for you in circuit court, just like we did in Macomb. So we need to waive exam just like we did in Macomb. Is that okay with you? Yes.
All right. So, Mr. Jackson, you understand that you're waiving your right to have a preliminary examination in these matters?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing on these matters and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all charges.
Your Honor, we acknowledge receipt of informations in both files. My client waives the reading, stands mute, asks that a not guilty plea be entered.
Trying to find the case. I have 4 counts on the case. I have 4 and 3, correct?
Correct.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 7 counts. Pretrial in this matter will be set for
February 23rd at 1:30 before Judge.
February 23rd, 2026, 1:30, Judge Hamoud.
Sorry, Judge.
Hamoud.
I thought you said Judge who?
I did not call
It's
it.
going to be one of those days, Judge. It's going to be one of those days.
All right. Bond will continue.
Thank you, Your Honor.
Thank
you. Court calls the case of the people versus Demarion White.
Andrew Childers appearing on behalf of the people.
Sir.
Morning, Your Honor. Please summon Court David Burgess on behalf of Marion White, who's appearing via Zoom from the Juvenile Center, Your Honor.
Mr. White, can you state your name, please?
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers are working toward a resolution. It's probably going to get bound over eventually, but we need a little more time at this level. So we're just asking for a couple weeks adjournment, Your Honor.
Returning to 5th, 12. All right. Probable cause conference will be adjourned to February 12th.
Thank you.
2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you, sir. Court calls the case of the people versus Margaret Patowski.
Andrew Childers appearing on behalf of the people.
Yeah. Patowski? Yeah, she's in Zoom, I think, but I need an attorney.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Patowski.
Ms. Patowski, can you state your name, please?
So muted. A case law in there, because everything else was.
Ms. Patowski, can you state your name?
Margaret Patowski.
Thank you.
There you go. Your Honor, there was an offer made in this matter, and I did meet with Ms. Patowski at the Department of Corrections yesterday, and as soon as I left the department, was able to leave the department and get to my cell phone, I did reach out to Mr. Childers to let him know that she intends to accept the offer. Unfortunately, I don't believe he received it in time. It was like 4 o'clock, although I had a 1:30 appointment.
I'll then adjourn this out 2 weeks to the 12th, February 12th, 2026, 9 a.m.
Okay. And I apologize, Ms. Patowski. I know you.
Bond will continue, and hopefully then I'll have the paperwork and we can get it all settled. Okay, Ms. Patowski?
Okay, thank you.
All right, thank you. Court does call the case, People versus Procopio Vitale.
Morning, Your Honor. Raymond Cook with the people. On behalf of Mr. Vitale. Good morning, Judge.
Good morning.
Mr. Vitale will be approaching. Please state your name for the record once you get up here.
Procopio Vitale.
And if you wouldn't mind just signing here.
What are we doing?
Your Honor, today's date and time set for probable cause conference. We will be waiving the preliminary exam at this time. Mr. Vitale is executing a waiver form right as we speak. Handing it to Deputy Allen.
Is that correct, sir?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Stand mute as to reading, or waive. I got there eventually.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for February 12, 2026, 1:30, Judge Slay.
Okay, thank you, Judge.
Bond continued. Thank you. Calls case of the people versus Tiffany Peters.
Go on behalf of Ms. Peters. Judge, it's the attorney AG case.
I think it's an ADA case.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Judge, this is a PCC matter. I had a long.
Want to state your name?
Oh, I'm sorry, Robert J. Kill on behalf of Ms. Peters. Sorry about
Ms.
that.
Peters, can you state your name, please?
Tiffany Comer Peters.
Thank you.
Judge, Ms. Peters is living in West Virginia now. This is a child support matter. She's current in her payments as far as monthly payments. I'm asking for a 30-day adjournment. Again, I had a long conversation with her last night. She can make between now and then, within the next week, she can make an $800 payment. And we're hoping she can bring this amount down to where we can work this out short of a felony, but we need some time to do that.
Going to be any objection from the people regarding that?
No, I would just like the attorney to get in contact with our office, but no objection, Your Honor.
Going to call their office?
If I know who to call. Yes, I will, Judge.
Thank you. Probable cause conference will be adjourned then to February 26th.
Thank you.
Thank you, Judge.
2026.
Thank you.
9 a.m. Bond.
Thank you. Appreciate your consideration.
Court calls the case of the people versus Gary Carmichael.
David I. Goldstein, appearing on behalf of the defendant. State your name, Gary.
Gary Carmichael. Thank you.
Setting this matter for exam, Your Honor. I do have all the discussion.
People have their witnesses available to 10.
Your Honor, I'm going to be gone the month of February.
The whole month?
Yes.
That's right. Is he held on something else?
No, Your Honor. I was going to make a bond motion in a moment, Your Honor, but
people going to be opposing a release in this case?
I would just ask for a tether as well as a potential silver leaf.
Okay, here's what I'll do. Will March 3rd work for you?
Your Honor, I've got a trial starting on the 2nd. I can do the 10th.
Okay. All right. So what I'll do is preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington. What I'll do at this point is I'll have his bond continued. You two send a stipulation over with the conditions and then I'll sign off.
All right, thank you.
All right.
Thank you.
Thank you. Court calls the case People versus Randall Laird. AG. Is that for AG?
Morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dodgy Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird.
I need a camera, sir.
I'm working on it. I'm sorry.
What are we doing?
You're going to be requesting an adjournment. I did just receive full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that on the page you can say. 26. Yeah, so let's do it that way. All right, probable cause conference in this case will be during February 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Patton.
Mr. Patton, can you state your name, please? Andrew Spencer Patton. Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That is correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, Your Honor.
And that you would be sentenced before Judge Perry in the 15th District Court. You
Yes, Your
understand that? Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court?
Yes.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
February 27th at 8:30 before Judge Perry.
February 27th, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
He was the first here.
Are you going to be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're going to have to find a way to.
I can find a way.
to test. Because if I let you out, we're going to end up in the same boat again. If you don't go over there and don't test.
I can go test. Sir. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
Thank you. That's what I need to do. CC order. Just want it put back to where it was. Court does call the case, People versus Michael Padola. Yeah, I see him. Who's his attorney? Who's his attorney? Mr. Bennett? Really? Mr. Bennett? Sir, state your name.
Michael Bedola.
I'm gonna pass your case. We gotta wait for your attorney to show up.
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Cadena South.
I'm sorry, did you call Bedola? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court.
Kadena Gill Self.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th.
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond bill, we requested 25,000 cash period. This involved Ms. Self stabbing the victim in his shoulder with a screwdriver. He had 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to his car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration. I believe, or additional charges. Calling someone names isn't enough.
Well,
But as for that's,
stabbing with a screwdriver, that would do it, wouldn't it? You don't need to say anything. Motion for bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point.
Okay, friends, good morning once again to all of you who have just arrived. Good to have you all here. All of you who have been here, I hope your day is progressing well. Let's change it up. Let's go to Ohio, Judge Collada.
We are here in the matter of the state of Ohio versus Richard Adams, case number 26 CR 00003. Defendant is present in open court with their attorney, Chad Mulkey. We are set today for an information hearing. It's my understanding that the defendant will be pleading to count 1, aggravated possession of drugs, a felony of the 5th degree with the attached forfeiture specification. Count 2, obstructing official business, a felony of the 5th degree, and count 3, misdemeanor theft, a misdemeanor of the 1st degree. There is no agreement regarding sentencing. The state would request a pre-sentence report and drug and alcohol assessment prior to sentencing. Thank you.
Thank you. Mr. Mulkey, does that sound accurate?
It does, Your Honor. It does, Your Honor. Thank you.
And Mr. Adams, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes, sir.
They indicated to the court they believe it's your desire to waive the right to have this case presented to a grand jury, and I'll explain in a moment in more detail what that means.
Yes, sir.
Then to go ahead and plead guilty to the charges and the information, which I will also review with you. We would then defer sentencing to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor? Most importantly, what you want to do here today?
Yes, sir.
Well, before I can accept your plea, then I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions.
Yes, sir.
If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Well, let's get started then. How old are you, sir?
48.
48?
Yes, sir.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No, sir.
Now, you should have received, or did you receive, I should ask, a copy of the information that was filed in this case. That's the document that sets forth the specific charges you're accused of committing. Did you get that?
Yes, sir.
And you had a chance to look that over at some point?
Yes.
All right, well, I'm going to go over those charges with you again, and if you have any questions, make sure you ask. But in count one, what is alleged and what you're admitting to is on or about December 20th, 2025 in McNally, County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, sir.
Any questions for me about it?
No, sir.
Now, there's also what's called a forfeiture specification that's a part of this charge, which alleges that during the commission of the offense, you possessed or had an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal just because of the nature of the property itself.
Okay.
An instrumentality is some type of property that there may not be anything illegal about it, but it's being used illegally or to facilitate a crime. You can't use it or possess it for that purpose. And here it's alleged the methamphetamine itself is the contraband. And the whole point of this is that you forfeit any ownership interest you have in that property. It allows the state to properly dispose of it at the conclusion of the case. Any questions about that?
No, sir.
Now, count two, what's alleged here is on or about December 20th, 2025 in Middleton, County, Ohio, that you did enact without privilege to do so with the purpose to prevent, obstruct, or delay the performance by a public official or of an authorized act within the public official's official capacity that hampered or impeded the public official in the performance of the public official's lawful duties. The violation created a risk of physical harm to any person, which makes the offense obstructing official business a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, sir.
Any questions about it for me?
No, sir.
Now, count 3, what is alleged here is on or about December 20th, 2025 in Middleton, County, Ohio, that you do with purpose to deprive Meyer, the owner of property being store merchandise, that you knowingly obtained or exerted control over that property without the consent of Meyer or anyone else authorized to give consent. The value of the property is less than $1,000, which makes the offense misdemeanor theft, a misdemeanor of the 1st degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, sir.
Any questions about it?
No, sir.
So you understand the nature of the charges you're pleading guilty to?
Yes, sir.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have this case presented to a grand jury. So that document I just read to you is called an information. An information is a criminal charge that's brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. Now, at a
Yes, friends, I just paused this for a second because I need to ask you guys a question. There's going to be a little bit of a choose your own adventure option, and I'm going to put a poll up so you let me know what you want to do. I'm just going through the feeds, and right now there was a jury selection yesterday in Judge Wade Mercer's court, and he's running a trial today. Now, I can't tell you the last time, if ever, that I've actually caught a trial in Wade Mercer's court, and this is a judge we like, but it seems to be about as rare as trials were in Judge Fleischer's court. So my question is, do you want to watch that today? If you do, I have no idea how long it's going to take. I can carry it through the 4th hour. If it goes over that, we could continue with it tomorrow. It's kind of up to you, but I'm going to put up the poll now and let me know what you think. Obviously, if we start there, that may be all we watch today from that point on. And again, I'd carry it through the 4th hour, but if it goes over that, I'd record and continue tomorrow. So let me know your thoughts.
grand jury is it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not, and you have that right as well. But you can't give up that right if you desire and go forward in the charge brought by the prosecutor and this information, and your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession here at this time a document called a waiver of indictment, which sets forth what I just indicated to you and explained to you regarding the grand jury. Before I can go any further, I need to make sure you understand what this document says and that you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Smoke, is that accurate? Did you review this with your client? Go over it with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Adams? You understand what this document says?
Yes, sir.
Do you have any questions for me?
No, sir.
It also appears you signed the document. Did you sign it?
Yes, sir.
Smoke, you witnessed that?
I did.
Ms. Johnson?
I did.
No, you need to sign it, though. You didn't sign this. All right, this document will be made part of the record. At this point, Mr. Adams, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. First of all, I have a right to a trial. And the trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who will listen to all the evidence each side wanted to present. Those jurors will consider and weigh all that evidence, and then those 12 jurors will make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right?
Okay, friends, the vote seems to be clear. You all want to go watch this Judge Mercer trial. I've got no idea what it's about. I've got no idea what's going on, so we're just going to figure it out together. And again, I'll carry it as long as I can today, even into the 4th hour. If it goes over that, then we'll pick it up tomorrow, but I've already started a recording on it. This is very procedural right now in Judge Collada's court, so let's just go down to Florida, and we'll get it started. Wade Mercer.
Call and then come back. That was a joke. I do have cough drops. You need a cough drop? These are Rico Lays. E. coli. I've learned no, but I don't buy cough drops for taste. I buy cough drops for effectiveness. Some of the best cough drops are Fisherman's Friend. They're also some of the worst tasting cough drops, but man, they work. All right, ladies and gentlemen of the jury, come on in. Just sit wherever you want to be. You can use the whole jury box. You do not have to sit in the seats you were in Monday. You can spread out, make yourself comfortable. It is flu season, so if you want to put a space between you and your neighboring juror, that's perfectly okay. If you want to sit right next to each other, that's okay too. I think every seat in this jury box, you can see the witness stand. Who's that behind Sissy? All right, everyone please be seated. Mr. McDaniel, I failed to ask you, no, I want you to hang on just a second. Mr. McDaniel, I failed to ask you in the preliminary instruction 2.1, there's a section to be given if defendant requests. Are you requesting that instruction?
Which instruction is that, Your Honor? 2.1.
I'm sorry.
What instruction? is that?
2.1 is the standard instruction, and there's a instruction, I don't want to, you want me to see a sidebar? Mr. Mitchell, Mr. Gill. You get there's another one at the end that you can request her. All right, let's make sure we got our jurors. So we have Ms. McGriff, we have Ms. Henderson in the back, we have Ms. Ross, we have Mr. Jackson in the back, Ms. Sprague is in the front, Ms. Williams, and Ms. Lopez Santana is in the back. All right, so does the state defense agree this is the jury that was chosen to hear this case on Monday?
Yes, Your Honor.
Yes, Your Honor. And Madam Clerk, would you please swear the jurors?
Do you solemnly swear or affirm that you will to truly try the issues before the court and defend it and render a true verdict according to law and evidence?
All right, ladies and gentlemen, there are some mandatory instructions I have to give every jury, and this is another one of those like we started yesterday. I think on Monday I gave you one. This is another mandatory instruction. Please listen carefully to the instruction I'm about to give you. Members of the jury, you have been selected and sworn to try the case in the state of Florida versus Jan Evelyn Pravat. Ms. Pravat is charged with 1 count of discharging a firearm in public. Count 2, improper exhibition of a dangerous weapon or firearm. Count 3, using a firearm while under the influence of an alcoholic beverage. The definition of these charges will be explained to you later. You must decide this case based upon the evidence presented and the law that I give you. Evidence consists of the sworn testimony of witnesses, exhibits admitted into evidence, and anything that I tell you to consider as evidence. The state's charging document, which is called an information, is not evidence and is not to be considered by you as evidence of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Ms. Pravat in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they will believe will be presented during the trial. What the lawyers say is not evidence, and you should not consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys, and documents and other exhibits may be introduced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their closing arguments, and following the closing arguments by the attorneys, I will then instruct you on the law of the case. After those final instructions are given, the alternate juror will be released, and you will retire to consider your verdict. One of you is an alternate juror. We do not, under Florida law, we do not tell the jurors which one is the alternate juror, and here is why. There's the concern or the possibility that that juror may pay less attention because they're an alternate. But the fact is that the alternate can become a juror, go from alternate to a regular juror quickly. Something happens, a medical event with a family member or one of you, then all of a sudden that alternate juror is no longer an alternate, they're a juror. So we don't tell the alternate, we can't tell the alternate who it is. But at the end of the trial, only 6 of you will go back in the jury room and deliberate. But I need all 7 of you to pay close attention because we don't know which 6 at this point, frankly. You should not form any definite or fixed opinion on the merits of the case until you've heard all the evidence, the argument of the lawyers, and the instructions on the law that I give you. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. Jurors must decide the case without distraction and only on the evidence presented in the courtroom. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, a cell phone, internet, electronic device, or any other means at all to get information related to this case or the people and places involved in this case. You may not visit places mentioned in this trial or use the internet to look at maps or pictures to see any place discussed in the trial. If you investigate, you research, or you make inquiries on your own, then I have no way to ensure that the information you obtain is proper for the case. The parties likewise will have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and to challenge the evidence being considered against him or her, and to present argument with respect to that evidence. An independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity which our judicial system promises. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, or even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication such as emailing, text messaging, posting information on social media websites, or any other form of communication. During the trial, we will take recesses. You will be permitted to separate and go about your personal affairs. It's important that you understand that during these recesses, the prohibition on communication about this case still applies, whether you're in the courtroom or somewhere else. If at any time you find yourself in a situation where others are discussing the case in your presence, leave that situation at once and immediately report the matter to the bailiff, who will advise me. We typically will take a mid-morning break around 10:30-ish. We'll try to stop at the end of a witness if we can and not break a witness's testimony up by a break. Normally we'll take a lunch break, come back after lunch, take a mid-afternoon break if the case is still going, and then finish out the case. That's kind of normally how it works. If at any point you need to use the restroom, raise your hand, let me know, notify the bailiff or myself, and when we get to a good stopping point, we'll take a break, let you use the restroom. Is there coffee in there? Our clerk of court, Mr. Rooks, has provided some coffee. I also got some a few snacks, a couple of some bottled water, Coke, Diet Coke are all in the jury room for your breaks. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or people involved in the case. Do not take photographs, video recordings, or audio recordings of these proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or electronic devices. If someone needs to contact you in an emergency, then we can receive messages and deliver them to you without delay. A contact number will be provided to you upon request. So you keep your cell phone with you throughout the trial. It's just got to be off. You have it during recesses, you have it during breaks. When deliberations begin, when you've heard all the testimony and I've given you the law, when you begin your deliberations, you leave your cell phone in your chair. You cannot take your cell phone with you in the jury room at all. It stays out here. A bailiff is assigned to watch the courtroom so that your stuff won't be messed with, but you will be allowed to have your cell phone with you until deliberations begin. At that point, the law doesn't allow you to have it with you. It stays in the courtroom or in your vehicle if you choose. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. The attorneys are trained in rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made, and likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor on what a witness might have said had the witness been allowed to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last, but when such conferences occur, they will be conducted to consume as little of your time as necessary for a fair and orderly trial in this case. You saw me do that Monday. I met over here with the attorneys at the sidebar. Ms. Williams cuts on some white noise just to make sure that what they say is on the record, on this microphone over here, but not so the jurors can hear. If that happens, we'll do it over here. If it's going to be a lengthy conversation, if it's something that's complicated, we're probably going to ask you to have a seat in the jury room, and then we'll do it in here while you're seated in there a little more comfortable. So if it's short, we're going to do it over here. If I think it may be more lengthy, we'll ask you to have a seat in the jury room. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. They will be left up to you individually. You have been provided with a notepad and a pen for each of you that wish to take notes. Everyone have a notepad and pen if you wish. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. So during recesses, your notes will just stay in your chair and they'll be here when you get back. No one reads them. During recesses, the bailiff will take possession of your notes and return them to you when we reconvene. After you've completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. So the way we do it here is you take your notes, you take them with you during the deliberations if you wish. And then afterwards, I will personally take your notes. I will personally take them downstairs to the shredder and I will personally shred them. I do not read them. No one reads them. I shred them myself. That way the law is protected. We know that your notes are your notes. So they're with you during deliberations, but afterwards, no one sees them. No one reads them. I don't even read them. If you take notes, do not get so involved in note taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Mr. Mitchell, any objection to those opening instructions as given? Did I miss anything?
No, Your Honor.
Mr. McDaniel?
No, Your Honor.
All right. And Mr. Mitchell, do I have you request the podium for your opening statement?
Not for the opening statement.
Mr. McDaniel, do you want it for yours? Mr. Mitchell, whenever you're ready, sir.
All right. Thank you, Your Honor.
Yes,
May it
sir.
please the court.
Yes, sir.
Good morning, everyone. So let me take you back to November 18th, 2025. Ashley Nichols, who you will see and hear from today, she is going to pick up her wife, Alexis Nichols. You may also hear her referred to as Desiree, but she's going to pick her up from work. It's late at night. It's about 10:30. They don't have any plans, so she just picks her up and they go back home. Home to them is a shared property with Ms. Jan Pravat. Their living situation at the time was Ms. Pravat had a piece of property in which she had a house on it, and about 100 yards behind her house, maybe a little over that, was a trailer that the Nicholses lived in along with their 3 children. One of those children you'll hear from today also, and I'll tell you more about him later on. But the only way that they can access their house is through this driveway. It's a shared driveway, and it's the only way in, it's the only way out to get to their house. I'll get on that driveway a little bit later on. But nonetheless, Ashley is driving Alexis home, and they're taking this driveway. Like I said, it's a shared driveway, and they're having to pass by Miss Pravat's house, and they're having to pass by the house at a slow rate of speed. Why? I anticipate that Ashley, Alexis, and the deputies that you will hear from today will tell you that this is not a very well kept road. There's divots, there's potholes in it. I anticipate Deputy Swift is even going to say that it's a road you can't traverse at a high rate of speed. So they're having to take their time, drive down this road to get to their house. And as they're driving by Ms. Pravat's house, Ashley and Alexis both see Ms. Pravat outside on her front porch next to another vehicle that's not Ms. Pravat's, but it belongs to someone that they recognize. And I believe they'll say that they just saw Ms. Pravat standing out front, just kind of posturing and just kind of staring at them as they roll by. They don't say anything. They just keep driving. They keep driving slowly by. But at some point, Alexis and Ashley both hear Ms. Pravat yell something at them. They can't tell what she's yelling to them. It's unintelligible. So Ashley asks Alexis to roll the passenger window down. She does, and Ashley says to Ms. Pravat, if you want to talk, then we can talk. She continues on, never gets out of the vehicle. And it's about a little bit more of a distance down the road when they look back and they now see that Ms. Pravat has come from the front porch, made a circle around her yard, and is now standing on the back porch. They can tell it's her standing on the back porch because she's still standing in that posture stance that she had and staring at them. And they know it's her. They can't see her face, but they can tell it's her based on that stance. They can only see the silhouette because that back porch is very dark. And they'll elaborate more on what happens in the next few seconds. But to skip forward, what happens in the next few seconds is as Ashley and Alexis are continuing on down this road, they hear gunshots get fired off in the air. I anticipate they'll say maybe about 3 of them, 2 in rapid succession, slight pause, and then another shot get fired off. Ashley will testify that she only heard the gunshots, but Alexis will testify that she not only heard the gunshots, she could actually see the muzzle flash coming from that back porch. Remember, she's sitting in the passenger seat. So she has a better view of Ms. Pravat on that side. And at this point, they're terrified. They're scared. They hear shots going off. They're not only scared for themselves, they're scared for their children. They're scared for their 3 children that are currently in their house behind where these shots are being fired off. One of those children you'll actually hear from, Jacoby Highsmith. He's the oldest of their 3 children. He's 14, and at the time of the shots being fired off, he was actually walking out on the porch where he was waiting on his moms to come in. He will testify, or I anticipate he will say that he heard the shots and he also saw the muzzle flash. Like his parents, he's scared. He's terrified. And being a good older brother that he is, he actually goes back inside, tells his other 2 siblings, get down, take cover. Ashley and Alexis do the same thing. And after a little while, when the shots have stopped or there's like a piece of quiet, they all 3 call 911. And that's where you'll be introduced to the 2 deputies that sort of took over this investigation. Deputy Ryan Grover and Deputy Michael Swift. Now, Deputy Michael Swift, or Deputy Swift, he's the one that sort of runs this investigation. At the time, he was an FTO, or a field training officer, and he was working with Deputy Grover. So they respond to a call. They get a complaint of shots fired in the area. Now, I'm sure you can assume that anytime a law enforcement officer hears about shots fired in the area, they're going to be on high alert. So they make their way to Burke Street in Grand Ridge, Florida, where this call was coming out, where these shots allegedly came from. And they go to the front door of Ms. Pravat's residence, and they make contact with Ms. Pravat. And what I anticipate you'll hear from Deputy Swift is that just upon making first contact with Ms. Pravat, he was just hit in the face with this strong aroma, the strong odor of alcohol coming from Ms. Pravat's breath. Now, Deputy Swift, he's been with the sheriff's office for a short time, but he's been with other law enforcement agencies. And in his time with other law enforcement agencies, he's had a lot of training and experience when it comes to investigating DUI cases. And I say that because he has this training to examine or observe signs of impairment when it comes to these DUI cases. And I anticipate that he will tell you, he observed a lot of these signs or indicators. Some of these indicators include irregular breath, red watery eyes, swaying stance, and slurred speech. And during the investigation, he will actually tell you that he observed a clear, empty wine bottle just laying out in the front yard, somewhere around the camper that Mr. Bat had outside. But nonetheless, they have an investigation to conduct. So Deputy Swift reads Mr. Bat her Miranda rights. And after he reads her the Miranda rights, she agrees to speak with him. And almost immediately, Deputy Swift asks, what happened? She says, fired a gun in the air. Post Miranda, she says that. And she says a lot more things post Miranda, and you will actually see and hear these post Miranda statements on Deputy Swift's body cam. But the summary of it all is that she admits to firing a weapon in the air. She admits to firing it from her back porch. And she can't give Deputy Swift the exact amount of times she shot and whether or not she reloaded the revolver that was used. That's what she gets. That's what Deputy Swift gets from Mr. Bat post Miranda. He then goes to speak to the witness that was also there at the time, Christy Jo Basker. Now, I won't tell you what Christy Jo Basker said to Deputy Swift, but what I will tell you is that Ms. Basker sort of gives Deputy Swift a walkthrough of the area. He takes her, or she takes him to the back porch, and he discovers that this back porch, where, remember, Ms. Purvette admitted to firing the weapon from, is dark. The light's busted. It's not working. And he comes to the conclusion, or he finds out that the light is not working from that back porch where she shot the weapon in the blinding darkness. He gets the statement from Miss Bassford, and then he makes his way to Ashley and Alexis Nichols. He makes their way to the property on the back. And that's where he sees firsthand and experiences firsthand the condition of this road, as it's already been talked about. He will tell you it's bumpy, it's unkept, it's unproven, all those words. But he makes his way to Mr. Bat's, or not Mr. Bat, but he makes his way to Miss Nichols's residence, get a statement from her, and after he gets the statement from her, that is when he concludes his investigation. At the conclusion of his investigation, he places Ms. Purvat under arrest for discharging a firearm, unlawful exhibition of a firearm, and using a firearm while under the influence of alcohol. And it's because of that, which is why we're here today. Now, ladies and gentlemen, I want to emphasize everything that you just heard from me, like the judge said, is not evidence, but what it is a preview of the evidence that you will see and hear today. You're going to hear a lot of testimony. You're going to see videos that may help you out in determining whether or not the state has proven its case beyond a reasonable doubt. But it is our belief that after you observe all the evidence, after you hear and all the testimony and all the evidence today, that the state has proven beyond a reasonable doubt that on November 18th, 2025, Jan Pravat discharged a firearm on residential property, unlawfully exhibited a firearm in the presence of another, and used a firearm while under the influence of alcohol. And after you have seen all the facts and seen that the case has proven its case beyond a reasonable doubt, you will return a verdict of guilty as charged on all three counts. Thank you.
Thank you, Mr. Mitchell. Mr. McDaniel.
Thank you. I think I will take that. counsel. So most of the facts are in agreement, not all of them, a lot of them are. I'll start off with a story. As I think I told y'all before, I'm born and raised here. Grew up in a farming area, in the farm, our whole family farms. I remember a time when I was young, buck 14 or so, working in the watermelon fields with my uncle, my dad, and some other family members. And we had some help there also, always. And I remember old man, Mr. Pittman, God bless his soul, he's passed away now. Good man. Me and him, he was getting paid $5 an hour to work out here. I was getting paid $2. I was kind of upset with him. I'll be honest with you. I'm got there working, getting $2 an hour, and he's working, getting $5 an hour. We had a few disagreements, and it was probably mainly about money, I suspect. I was making so much money. And I remember I thought I was bright enough I was going to get to a fight with the old man. He's probably in his 50s, good fellow, good man. Out there, you work with people, you get upset with people sometimes, especially in close contact. My uncle pulled me aside and he said, "Boy, what do you think you can whip that old man?"
Your Honor, I'm going to object. Stick to the facts of the case. This has nothing to do with that.
I'll get y'all to approach, please.
Okay, friends, let's take this first sidebar to remind you that we have sidebar tonight here on TCF, 8 p.m. Eastern, 5 p.m. Pacific. It's actually going to be inspired by the Judge Stevens case that we saw yesterday with the guy who had 5 DWIs. So be sure to check that out.
So he pulled me aside and said, "Boy, you may think you can whoop him, and you may be able to whoop him. You take on an old man like that, he's not gonna fight you, he's gonna kill you." We all know that old proverb is basically this. It basically says that never pick a fight with an old man. He's too old to fight, he'll just kill you. And we got a younger female who the state's is painting as he said she was yelling out, "If you want to talk, we can talk." I think you're going to hear a lot of evidence today that say that she's not someone that just says, "If we can talk, if you want to talk, we can talk." I don't even know if she knows that language. You skipped over the mindset of the defendant is in play today. She's in fear for her life from this lady. Again, I think I'll bring this up. You probably shouldn't contract with family members. She's a renter out there on her property, in the back part of her property. Just to give you a picture of the property, just so y'all have an idea of it.
I'm going to need prosecute PC1. No audio.
So this is the property we're describing here. We're talking about everything. The house to your left is where she lives at. The house to the right, about 300, somewhere in there, either way, is the house that she rents. The driveway to the left is the older picture that's been closed off. And you have to go around right and then go around this little marsh area, pond area over here to the house. Driveways around the other way now. This is where it's at. So I just want to let y'all see that. You'll probably see it some more later on, just kind of give you an idea of what the properties are. There's no doubt she shot the weapon. She shot the weapon. She's in fear for her life from this lady. They skipped over and they didn't want to talk about the acts that happened prior to this, that come to this.
Yeah, I'm good. Can we approach?
Yes.
Well, the most interesting thing for this so far, for me anyways, is the fact that this is now our second sidebar and we're not even through opening statements yet. So this should be a hoot. But But that's okay. It'll be fun. I'm looking forward to spending some time here because, again, I can't recall the last time, if ever, I've been paging through and seen an actual trial with Judge Mercer. Usually it's just, first appearances and traffic kind of stuff. So we'll see. But again, we'll hang with this for as long as we can today. And if it carries past how long I'm able to broadcast to you, it is recording. So we'll just pick it up tomorrow. But it will be fun. All right, let's hang here and wait. If I've got stuff queued up, so when we have the longer pauses, recesses, and stuff, we'll have something to watch there too. Daniels Nina says the defense seems to be trying the case in the opening statements. That does seem to be the case, doesn't it? I can't even recall in Judge Boyd's court where I've seen more than a single interruption during opening statements. Interesting. We'll see where this goes.
I'm gonna go back to the day in question, the 18th. You're going to hear witnesses that's going to say that she's not this peaceful person. You're going to hear witnesses to say, well, I'm going to leave it at that she's not this peaceful person. I think it's going to become clear to you later on. And just so be cautious of what you hear, listen to it carefully, and wait for some of the stuff that's going to come through here. So the state says she comes into the driveway. First of all, same day of this incident, there was an altercation. I guess maybe words were spoken between Christy Joe, who was there at the property, and Ashley at the dollar store right before this happened. Christy Joe come over there to see Ms. Pavette right after she left the dollar store. After this little incident, Christy Joe's standing on the front porch, and they come into the driveway while she's on the front porch and starts hollering and screaming, basically, I'm going to kill you, bitch, and y'all are this and that, and vulgar words, something that's pretty common. If you want to talk, we can talk. I love the sound of that. But that's what she was screaming out. That's what she was speaking out of the window. If we can talk, we can talk. She was screaming out vulgar words, vulgar language. Christy Joe walks inside and tells her about it. And then she walks out to the back. Then when she's in the back, the car stops, goes forward, stops, the door opens up, the lights come on inside the vehicle. You can clearly see the lights come on the vehicle when the door opens. Her wife, Ashley's wife, is then screaming, get back in the car, get back in the car. Don't do anything, get back in the car. She then goes into the house and gets her gun. I think it's pretty reasonable. She's scared to death of this lady. A lady that I'm gonna say has lived her whole life, like a lot of people in Jackson County, and don't lock the doors, which will come out later. She goes inside and she gets her gun. She comes back out. They're still out there screaming. They start to drive off. Yes, she shoots her weapon up in the air, straight up, and says, don't come on my property, back over here on my property. She's also been trying to get her to get out of the house for quite a while because she won't pay rent, which is why you don't do contract with family members. There's multiple things going on here, but ultimately, Ashley's a bully. She wants to push everyone around, do everything, and you're going to find out that basically she calls the police a lot. She's very familiar with the police. She's very familiar with the justice system. She tries to get a hold of it first. She tries to call them first because she knows that she can get the sympathy of the police when she calls them first. So why in the world, you question my mind, why would 3 people in the same household call 911? When he said that, I was like shocked by it. So 3 people in the same household call 911 because they're so scared. Over, you see, it's, they say in the household is, 350 feet away. That's a football field and a quarter away. I understand that gunshot goes off at night. I'm not going to just totally discount that as nothing. It is something. Oh, it's around 10 o'clock, I think. It is something. But all three of them calling 911, that seems like you're trying to gain an advantage or something with the police. And there sometimes whoever calls the police enough, sometimes I hate to say it, as the role that I'm in, gets the most preferential treatment because they just want to shut people up. They want to not get calls, have to go out there sometimes. So you got someone that's calling the police. She's driving down through there, making threats against her life to kill her. You're going to hear some evidence today about that. And she is scared to death. After she shoots, her first reaction is to take the gun back inside and lock her doors and ask Christy Joe, who was there, help me lock the windows because she's scared to death of the woman. There is a history of Ashley scaring people. She has a propensity for violence. And we hope to bring that out in this trial. And I just ask y'all to listen to the evidence carefully, evaluate the people. Remember that Jan's an older lady. They're going to say, well, look at these discrepancies. When you see someone who has their story completely straight, everyone says the same thing, it's questionable. How can the rule? Because everyone sees things differently. Everyone sees things differently. If you see somebody with a green shirt, someone next to you is going to say it's a blue shirt. Everybody sees things differently. When everything comes out and it's like everyone has the same story, you got to ask yourself, how in the world did everyone see the same thing? Listen to the testimony carefully. Listen for some issues that may be coming up. And her state of mind is definitely at play here. On top of that, they talk about her drinking alcohol. It's not illegal to drink alcohol and handle a gun. Police in the state try to make that to be an issue. Your normal faculties have to be impaired. Just drinking alcohol is not no issue. If you're drunk falling down, you probably shouldn't be holding a gun. She safely held a gun, one of it straight up, shot. One of it straight down. The state's even gonna say she went inside. Don't really recall it because her stress level so high, reloaded the gun. Took the bullets out, or I don't know if she reloaded or took the bullets out. And as she's talking to police, she don't recall. She's like, go in there and check. It's in there. I don't know. She's basically stressed out. She has a lot of medical issues at her age that contribute to that. Police don't even ask her anything about her medical issues, but she's had a stroke. She's got heart failure, congestive heart failure. She's got afibrillation, which causes her heart to pump rapidly. And you can kind of see that in her that night because she's very excited, very everything's, basically setting her off, her heart's just pumping like crazy. She's not thinking straight. And the state's going to try to make an issue to say that, oh, look, well, she said this, and this right here is really what it is. Is that someone that's a criminal? Is that someone that's just that's in an excited situation and is not thinking clearly? And this is going to come down to, basically Alexis doing whatever she can to aggravate and drive this lady crazy to try to kill her, which she explicitly says over and over. And I hope that evidence comes out and you'll hear about that. Just listen to the case carefully, and I appreciate y'all being here today, and look forward to getting started.
All right, thank you, Mr. McDaniel. Mr. Mitchell, your first witness.
Yes, Your Honor. The state will call Ashley Nichols to stand.
We need that. Mr. McDaniel, Ms. Nichols just standing right there. Mr. McDaniel, do you not want this microphone on the table for some reason?
I just don't know, because everyone hears everything I say.
The problem is if you object, it's not going to be on the record. So you're going to have to come up here every time you have something to say, or we're not going to have you on record.
Could turn the mic towards him.
Just a second. There's already one on the jury. You want to put it on the corner of the table away from y'all or something? You can just pull it to you if you need it. Okay, so Ms. Nichols, I'm going to ask Deputy Clerk, Ms. Williams, to place you under oath, and then we'll get you to have a seat. So Ms. Nichols, going around, have a seat in the witness chair, please. Just make yourself comfortable, Ms. Nichols. And Mr. Mitchell's going to ask you some questions first. Mr. Mitchell.
Thank you, Your Honor. Good morning, ma'am. Can you please
Morning.
state your name?
Ashley Nichols,
And Ms. Nichols, what city do you currently reside in?
Mariana.
Is that where you lived on November 18th, 2025?
No, sir.
Where did you live on that date?
At 6934 Burke Street in Grand Ridge.
And that address is in Jackson County, Florida, correct?
Yes, sir.
So tell me what you were doing on November 18th, 2025.
I had drove down to the Dollar General in Grand Ridge to pick up my wife for work. She was closing the store that night.
About what time did you get there?
Around 10:15, probably.
And when you picked her up, did y'all have any plans set that night?
No, we were going back home to the kids.
Okay. You said you have kids. How many do you have?
3,
Can you tell us how old each of them are?
7, 13, and 14.
And your house, well, let me ask you this. What's the living situation like at your address?
Currently?
No, on November 18th, I apologize.
Okay. The living situation, it was pretty rough.
And why would you say it was pretty rough?
We were living without heating or cooling and very limited plumbing.
Were you renting at the time?
Yes.
Who were you paying rent to?
Jan Pravat,
And who is Jan Pravat to you?
my mom's cousin.
Okay, so a family member.
Yes, sir.
And were you living on our property?
Yes, sir. It's part of the acreage there.
And where was your house in relation to her house? Was it in front?
It was behind. It was off in the back, close to the tree line.
And how would you get to your house?
Circling around the left side of her house and then cutting to the back right corner of her house to go back to our property.
Do you only have one way in and one way out?
Yes, sir.
So it's a mutual driveway.
Yes, sir.
How would you describe that mutual driveway?
Very rough and unmaintained. It's just really bumpy. There's holes everywhere and puddles everywhere.
All right. So it's unkept.
Yes, sir.
All right. And when you were coming home, did you have to take that driveway to get to your house?
Yes, sir.
And I think you mentioned this. Do you have to pass by Jan Pravat's house to get to yours?
Yes, sir. The pavement ends directly in front of her house.
So on November 18th, when you were going down that driveway, passing by her house, what did you observe?
Her standing in the doorway as like a bully stance, because I've known her my whole life. So I know that's how when she gets upset.
Now, that could mean a lot for the jury, and you can stand up if you want to. When you say bully stance, what do you mean?
Had on, it's the one that comes out. She had it on.
She's posturing. That's how I would interpret that. And is she just staring at you?
Yes, sir.
Was there anybody else there at that time?
Yes, sir.
How did you know that?
Because the vehicle was out front and her door was open.
Did you recognize the vehicle?
Yes, sir.
Did you recognize who it belonged to?
Yes, sir.
And who was that?
Christy Bassford.
Okay. So you're driving by her house. Are you saying anything to Ms. Pravat?
No, sir. My windows were up.
And you said that your wife was with you in the car, correct?
Yes, sir.
Was she saying anything?
No, sir.
Was Ms. Pravat saying anything?
I wasn't really listening because I had the windows up. I was trying to get home.
Okay. What happened after you passed by her house?
She followed me around her house and continued to step to each doorway doing that stance.
You say to each doorway. How many doorways did she go to?
3.
What doorways were they? I think you already said the front porch.
The first was the front porch, and as I moved around the house, there was a carport door on the side there. And then when I moved around the back, there was a back door, which she finally stopped at, was the back door.
And you're still continuing down this driveway at this moment.
Yes, sir.
What happened when she made her way to the back porch?
We were cutting across, and at that point, I'd cracked my windows, so she couldn't tell they were down. It was pretty dark, and she was yelling.
Could you tell what she was yelling?
No, sir.
What did you say in response?
I responded, "Hey, if you want to talk, we can talk."
And that's all you said?
Yes, sir.
What happened after you said that?
She yelled something, and the door closed.
And when you say the door closed, I assume you mean the back porch door.
Mhm.
And what happened after it closed?
A few seconds had passed, and the door swung open, and shots started firing.
So you heard shots being
Yes, sir.
fired. Do you recall how many?
I heard 3.
Okay. And were they in quick succession?
The first 2 were pretty pow-pow. The third one was slightly delayed from the second one.
And at this moment, how did you feel after hearing those shots?
Pretty scared and disturbed.
What'd you do after the shots?
I took off after the third shot had finally come to a stop. I took off across the field and tried to get on home.
Okay, so you're still in your vehicle at this
Yes, sir.
moment, and you pulled into your front yard?
Yes, sir.
Was anybody in the front yard waiting for you?
Yes, sir. Our 14-year-old was standing on the porch and endured the whole incident.
And what's his name?
Jacoby Highsmith.
Was he at the house while you went to go pick up Alexis?
Yes, sir.
Were you scared for him?
Yes.
Okay, so you said you gave a little bit of time after the shots were fired off. After the shots had stopped, what did you do after that?
Pretty much floored it and scooted across the field and got home.
Did you run inside?
Oh, yeah.
And at this point, were you in fear for your life?
I was scared for myself, my wife, the kids.
What'd you do after you get inside?
Screamed for the kids to just stay put, stay down, keep the lights off, and called 911.
So you called law enforcement?
Yes, sir. There were several people.
How long after you called 911 did you make contact with law enforcement? How long was it?
Approximately 30 minutes.
And you made contact with law enforcement?
Yes, sir.
And you provided a statement to law enforcement?
Yes, sir.
And that statement is what you've testified to here today?
Yes, sir.
And finally, is Jan Pravat in the courtroom today?
Yes, sir.
Can you please point to her and identify her by an article of
She's
clothing?
here to my left with the red and black plaid.
Your Honor, let the record reflect that the witness has identified the defendant.
It will.
Just a moment. They will tender the witness.
All right, thank you, Mr. Mitchell. Mr. McDaniel. Ashley, it seems so weird that that's all that happened. You just were peaceful. You drove up there. And she just shot, and it was a hellhole to be there. What led up to this?
Sir?
What led up to this?
That's what I'm still trying to rumble in my brain.
Difficult to understand how you got to that point in there.
Pretty much. I think it had something to do with her company.
Had something to do with her company. So you and her company have some words, I guess, or something at the dollar store before you got there?
I don't know the lady. She come out and I was having a conversation with 2 friends outside the store. And she jumped in the conversation and slung a remark to me. So I turned around and made a statement back to her.
Pretty aggressive statement, huh?
Not really.
No?
No,
Okay.
sir.
Okay, just a peaceful statement. What kind of statement did you make to her?
I told her, well, we might want to watch the company you keep.
Okay. And that happened right before this, and you go up there and you continue your peaceful talk. I guess the way the prosecutor says it is, if you want to talk, we can talk. Out the window, is that correct?
That's what I spoke to Jan.
That's what you spoke to Jan. When you pulled up there, though, there was someone on the front porch and you pulled around. Were you stopping, backing up, stopping, backing up, going forward?
When I heard her yell, I backed up probably about 5 to 7 foot.
Okay. Were you screaming at her how you were going to kill her?
No, I don't recall that.
You don't recall that?
No, sir.
Okay. No. Were you calling her vulgar names?
I told her if she wants to talk, we could talk, and she stepped inside the door.
Okay.
The door shut.
Okay. She stepped inside the door and went and got her gun, I guess is what you're saying?
Yes, sir. About 8 seconds passed, so I believe it was on her table.
Okay. And during that 8 seconds, she comes back out and you were still there?
I was sitting stationed behind some equipment that was an obstruction between us.
Okay. You never got out of your car though?
No, sir.
Interior lights wouldn't have come on?
Sir?
Did your interior lights come on when the door opened? It's very dark out here though, isn't it? It's not a
It's
whole lot
very
light.
dark and her house was very bright, so you could vividly see her in the doorway.
Okay. And if your door would have opened, your interior lights would have come on in the car?
Yes, sir.
And it's so dark out here, it would have stuck out pretty easily.
Yes, sir. I would have glowed.
And did your door open?
No, sir.
You didn't open up your door?
No, sir.
You were
Not till I
screaming out
got
the
home.
window. You were just screaming out the window as you kept driving. But you said you stopped and you pulled back and you waited for her to go inside. What were you waiting for after she went back inside?
When the door shut, I was unsure if she was coming to my truck or if she was inside. I didn't know until the door opened back up that she was inside.
Okay, so you stopped there, you waited and to see if, because you wasn't for sure if she went, but it's very bright and you see it very well, but you're still not sure if she went inside or if she's walking towards you or something. Okay. And you're still yelling at her, I guess, from the car peacefully that if you want to talk, we can talk, the way the state kind of put it. Is that what you're still
That's the
yelling?
last thing I recall saying. And she screamed something, the door shut, and next thing, shots come firing at us.
Correct. So 8 seconds pass and you're still sitting there. You're saying peacefully in your car, asking her to talk. And then she comes out and you hear the weapon go off in the air.
Mhm.
Did you see her handling the gun?
I could see her stance where she come out the door that she wasn't in her stance that she was at.
You didn't see the weapon at all though?
I couldn't see it myself, but I'm looking through the truck.
And there was obviously some rental tenant agreements. You said that the heating and the air conditioning wasn't working. I think she would probably contend that the air conditioning was working. There was some issues with the heat. This was November. Have you been, how long have you stayed there?
We stayed there from June of 24 till this December of 25.
Were you there previously with another wife or another woman living there?
Sir?
Were you there previously with another wife or another spouse or also?
Before that time frame, was I living there?
Yes.
No, sir.
So you always lived there with just that wife there?
Yes, sir. That's the only residence I've shared with a person.
You said
there.
you had 3 kids. Do you have any kids?
No, sir.
You don't have any kids, do you? Okay, so, okay. When I called Noel, Catherine up here to testify, is she gonna testify that?
Your Honor, may we
peaceful-
approach?
Yes.
Okay, interesting testimony so far. I'm enjoying this personally. Curious to see where this goes. It kind of reads standard Florida, unfortunately, at the moment. And I hate to generalize like that, but this is, if there was a place that I guess we would see this kind of behavior, I think most people Florida would come to mind. And that's sad, but somehow true, I think. I don't know. Let me know what you think in the comments. Well, they're taking their dear sweet time on this one. Okay. Well, while we're waiting, again, a reminder, sidebar tonight, 8 p.m. Eastern, 5 Pacific. We're going to be discussing, or having a discussion rather, based at least initially upon the case yesterday in Stevens Court with the 5-time DUI guy. So that should be fun.
Whenever you're ready, Mr. McDaniel. So you lived out here for how long, ma'am?
Roughly a year and a half.
Year and a half. During that time, how many times police show up at your house?
Your Honor, objection. What we just discussed is sidebar.
Just asking. Just a second. That's not the same objection. Let me get y'all to approach again.
Wahoo suggests we need a sidebar counter. Wahoo, I will put you in charge of that. Then feel free. Keep us updated. For those of you listening on the podcast side, just a reminder, we are listening to a jury trial right now. So when we have these longer pauses, they are going to sidebar to discuss some things. So bear that in mind, because I have a feeling there's going to be way too many of these to edit them out on the podcast side. So we're just going to have to run with it.
Whenever you're ready, Mr. McDaniel. So to ask you, did something lead up to this final y'all were not, there was issues, I know, with, some of the heating, whatever. Did you pay rent?
Yes, sir.
How often did you pay it?
Monthly.
Paid it monthly, like
Yes,
you were
sir.
supposed to be paying it. Why has she been asking you for the rent in the past, and why did she have to go to you and ask you for it?
I've been on doctor's leave and it's just been my wife working.
Fine.
And we've paid rent by the agreement that we had between herself and us,
What was that agreement?
that she would only charge us a half month's rent until she fixed the things in the house that were broken.
Okay. And you were not working. Are you working now?
No, sir, I'm on doctor's leave until at least March.
So it's a family member, and she's giving you a break because you really can't pay rent. She gives you a really reduced rate to stay there. Is that accurate?
No.
How much are you supposed to pay rent?
Rent total was $750 a month.
And that's what is it, double wide, or what is?
It was a single wide trailer.
Single wide. And she let you pay far less than that though, didn't she?
We would pay her half of the $750 and then
Because you weren't
we
working?
paid whole.
Because you weren't working?
No, sir, that wasn't why.
Okay. And there was instances where she had to go to you and ask you for rent and say, hey, your family, but you still got to pay.
I
They were
told her
happy?
I would never do her wrong on the rent.
Okay. But there was instances you didn't pay though.
There may have been a time or two.
All right. And one of those times you got very upset, didn't you?
I don't recall.
Don't recall? You recall entering into her house early one morning when she had sent you a message or something about paying?
Objection, Your Honor. Relevance.
Let me get you to approach again.
So I think we can safely say in our first trial with Wade Mercer that stylistically he likes sidebars. much more than most other judges that we see. So we're learning here. I still find this interesting, again, just to get a different look at this judge that we've come to enjoy over the last months. But he do like his sidebars. There's no question about that. Austin says he likes our sidebars better. I would tend to agree. They're more entertaining, at least I hope they are, because that's what we try to do. But that's okay. This is all part of it. You know, I like doing this channel, and I like watching these courtrooms and stuff, because this is reality. This is how the system really works, not what we see on Law and Order, you know, property crimes under $50 or whatever version of Law and Order they're on now. This is how it goes, and it is sometimes slow moving. There's a lot of pauses, a lot of things that go on. And I wish more and more people would see this and experience it and have a better idea of exactly how the system works, because so many come into this, and we see it in court, don't we? They come into court expecting things to move like they see on television and work that same way, and it just is not the case. But that's why we're here at TCF. Educate and learn and have some fun.
So Ashley, your aunt, I guess, or I know y'all, so kind of extended family here. She normally keep her door unlocked, always unlocked.
Most of the time, it seems like it's unlocked.
And just to relieve the jury here, at some point in time after this incident, you either voluntarily left, or I think you were encouraged maybe by someone to leave and you left. Is that correct?
Left the property?
Left the property.
Yes, sir, we
left the
moved.
property, and, you know, after this incident here, you've left those, so no really may affect the family union, I guess, but it's not gonna, y'all not gonna be fighting over these issues, correct?
I can't hear you, sir.
Yeah, I don't know if it's a mic, that microphone's not active. If the one below you is the one that's active, Mr.
I
McDaniel.
apologize. So since you've left now, I mean, I was saying it may affect the family reunion when y'all get together, but y'all not gonna be killing each other out. Y'all not gonna be fighting on this property no more. Is that correct?
That's correct. I have no issue with her.
Okay. You don't have any issue with her?
No, sir.
Okay, all right. No further questions this time, Your Honor. I just subject to recall.
I don't know if the state was, I think the state waived an objection to, the state waived an objection, you asking the other question if you wish, and not having to recall her. Is that correct, gentlemen?
Yeah, y'all want to go down that?
That's the way I understood it at sidebar.
Yeah. Okay. Roger.
So Mr. McDaniel has a few more questions, okay?
Yeah, I apologize. Thank you. So because she always leaves her door unlocked, sometimes you felt free just to walk into her house. Is that, I mean, you're a family member. Does that sound accurate?
I would knock, and if I couldn't holler and get her to answer, I'd walk in and check on her because I've been concerned about her.
And nothing wrong with that. One of those instances, she had left you a message about the rent or something a few months back. Is that, you call that?
I'm sure I got messages in my phone because I don't delete anything.
And one morning you went there and I guess you knocked probably. I'm not gonna say you didn't knock, I have no idea. But she didn't answer and you entered into the house.
I'm unsure. It's likely happened, but I don't know what incident we're leading to.
Well, this incident, you may remember, I don't know, I would think you remember, but you may not remember. I don't know, where you got extremely upset about her asking about the rent, and you went in there and basically said that you know she's not working and you know she's not gonna get the rent until she's able to, while she's in bed with her CPAC, screaming and yelling at her.
We had many discussions that I told her, I'm not gonna do you wrong. I'm doing the best that I can.
And did that one there become aggressive?
We've always got along. I mean, we're two redheads, so we get along pretty good.
So in that incident, so sometimes y'all fight, and while she's in bed with her CPAC, she's not really in a fighting position. Did you?
We've never fought.
Never fought.
No, this is all new. This last year was all a whole new experience.
You didn't shove her while she was with her CPAC machine in the middle of the bed and start screaming at her and yelling at her. And attacking her. Yeah,
I remember the instance when she chest bumped me throughout her house and I asked her to please stop touching me. I asked her nice and then I told her to stop touching me.
So you enter into her house to scream at her about you not being able to pay rent, and you enter into her, not only her house, but you open the door and go into her bedroom where she's asleep with her CPAC machine and all of the things.
Yes,
that,
sir, I knocked.
You knocked, but she didn't answer, I guess, and you went on in. And basically it led up to an assault with them on each other. Is that correct? That sound about accurate?
No, sir, I didn't touch her.
You didn't touch her?
No, sir.
And the CPAC machine didn't get messed up during the tussle that you were in there tussling with her?
I did not tussle with her.
Okay. And obviously you said she didn't appreciate you just walking in, I guess. Is that, I think what you said, some of her.
I don't think it was a matter of me walking in. It was the context of what was actually at matter at that time.
That was about the rent?
More than likely, she was upset.
She was in bed sleeping, so if you come over, I think you would be the one that would be upset.
I come and talk to her because if anybody knows her, she's very hard to reach on the phone. And she was hop, skip, and jump away, so I figured it's easier to just talk to her.
Yeah. So that happened a few months prior. At some point in time after that, I guess she asked you to leave, I guess, was in a nice way.
Well, I'm confused because I don't know what led up to this.
I understand. So I'm gonna get to it. So at some point in time, she asked you to leave, things just not working out.
She did, and then things smoothed out after that from my viewpoint.
Okay. But you thought they smoothed out and you didn't leave though?
Yes, sir. We were planning to have a Halloween party.
I understand. And that was up before October 31st. What happened? So all this stuff led up to it, and she asked you to leave, but you think it smoothed out and you're not leaving. It led up to the week prior to this, which was November 11th. What happened on November 11th?
She had a man staying with her. He was named Harold, and he was using the bathroom and allowing himself to be exposed. Well, after we seen it time and time again, and I'd already spoke to her and asked her to please talk to him because our kids were seeing it, and he would not have any regard to who's seen it. And I got upset and I called her and told her I was coming to talk to Harold.
She don't answer her phone though, so you didn't talk to her, I guess.
I talked to her.
You talked to her. Immediately before you come over here, it wasn't about Harold, about that issue. It was about a dog.
Harold had said something to our middle child about, well, if the dog doesn't listen, just go ahead and kill it. And our kid got very upset and came home and was crying.
I don't know exactly what was said, but something was said from Harold, and I assume I was told it was some kind of joking manner that somebody that was there that'll be testifying of, about just put the dog down, you know what I mean? And I clearly can see it might could have upset a child. Immediately upon that, you weren't there, you don't know exactly what was said. You come over to her house, though, correct?
Yes, sir. I stepped to her carport.
Stepped to her carport in a fighting mode.
No.
Is that correct? Not in a fight, you stepped to her in a peaceful mode. Let's talk about this.
Jan was in her bedroom. Jan was not outside. I was talking to Harold.
Great. I'm talking about somebody that was out there though. So that would have been Aubrey Whitfield who was out there. Which Aubrey has the highest respect for you. I think she loves you to death. She was out there though, wasn't she? That's not what her recollection was. So she was out there when you come up. Is that correct?
I believe she was somewhere in and out, between in the house and out.
She was there when also the conversations about the dog.
I'm not sure.
Okay, yeah. So you come over from your house and you walk over there, and you get into an immediate altercation with Howard. Is that his name, Howard?
Harold.
Harold, you get an immediate altercation with Harold, I guess. Does that sound accurate?
I was trying to talk to him and he just clammed up and didn't speak, but she kind of intervened at that point, so the
Essentially, he
focus
didn't want to
was,
fight a woman. Would that be a correct assessment? He just kind of sat back and ignored you and said.
it
"I'm not
wasn't a
gonna fight woman."
fighting, it wasn't a
Okay,
fighting issue.
Stop, both of you. Don't interrupt her answering a question and don't interrupt him asking a question.
Yes, sir.
Ask a question. When he finishes asking the question, he will stop and you then answer it. I'm not gonna let you talk to each other, talk over each other anymore. So please ask your next question, Mr. McDaniel.
So you go up to Harold. What was your mood that you come immediately over after the child went back over to the house?
I was agitated
You were agitated.
because it'd been months of asking her to please ask him to be courteous.
You're asking him just to please be courteous. You didn't walk over to him and try to fight him?
No, I may have been yelling, but I was not going with no intention of fighting anyone.
Okay. There was so much yelling going on that Jan had to hurt it inside the house. Does that sound about accurate?
I'm not sure, and it wouldn't be nothing because it's a block house with the door open and it's practically empty, so it echoes.
I understand. So Jan comes out of the house.
Mhm.
What do you do when Jan comes out?
She started arguing with me and then everything just went chaotic.
As I've had many conversations with Jan, both y'all redheads, I can see that happening. So she comes out of the house that you're over there yelling at him and y'all start arguing.
Yes, sir.
What proceeds next?
She ended up picking up like a piece of threshold off that would be on a wall. It had nails in the end and she hit me across the head here with it.
And she was standing in her doorway, I guess, when you come up through the porch and you come up there to her
She had come out the carport door there.
and you walked up to her. You had to keep walking past.
Yes,
Harold
sir. I
and
was
walk up
walking
to
with my
her.
hands in my pocket and I walked up to her and she grabbed the board and cracked me in the head with it.
We all know y'all were both in a fighting mood. You were in a fighting mood too. You come up to her in a fighting mood, trying to fight her.
I wasn't interested in her. I came to speak to Harold.
Okay, but you ended up fighting that old lady with congestive heart failure. I mean, you know about some of the
Didn't
medical
fight her.
conditions.
She hit me in the head and I grabbed her and I pushed her against the freezer that was standing behind her and held her there.
You know about her health conditions.
That's why I'm concerned about her.
Okay. And you go into a fighting mode. You grab her, y'all both grab each other's hairs, pulling each other. Does that sound about accurate? Do you recall that?
Yes, sir.
She had you held down by the hair. You probably had her held down by the hair also. Some point in time, she was able to reach a board and she hits you with the board.
No, sir. The first start was the first contact. She hit me with the board and then I grabbed her by the hair and shoved her against the freezer and held her.
And is it safe to say Jan's a little bit scared of you?
No, not at all.
You're 35 years younger than her probably. I mean,
She's a tough one. She's not scared of anybody.
I
She'll tell
don't
you.
totally disagree with you. So, but you don't think she might be a little bit scared of someone that's 35 years younger than her that don't have the health conditions that she has?
No.
No. Okay. So she grabs the board, she hits you, y'all keep fighting, I guess.
It was more of a tussle. It wasn't really a fight, but I was still stove up from the wreck that we had on Halloween. And I was pretty much incapable of doing anything at this point. So she was just like pulling me, hitting me, whacking me. Like I
Understand.
I just kind of submitted whenever it let go and I had her against the freezer and she wanted to fight. I let go because I had no intention of hurting her.
You were very mad though, weren't you?
Yes, my family is sitting here beating me in the head.
Sometimes people say things when they're mad they probably don't mean. Does that sound accurate?
Sounds pretty accurate.
As you're walking off, you threatened to burn her house down with her in it. Does that sound accurate?
Sounds like what I've been told to. So
I mean, is that what you told her? You know?
May have.
Okay.
I can't
think that
confirm or deny.
You think that someone who's living 350 feet from them, who's threatened to burn their house down, may make her a little scared?
Not this lady.
She's just that tough.
Pretty tough.
They'll come from a tough family. I know y'all do. What did Jan do for a living?
When she was working, she was a beautician out at Sunland. She's always cut hair as far as I can remember, other than working in a lunchroom.
And she retired from the state?
Yes, sir, I believe so.
She retired getting, I guess, whatever benefits she gets from state retirement. Have you ever known her to get in trouble before?
Not in a court setting.
You ever known her even have to call the police?
Her call the police?
Yeah.
I believe so.
Okay. So going back to November 18th, all this drama has been going on. You even admitted, basically, yeah, that sounds like something I'd said, that I threatened to burn her house down with her in it. You don't think she's a little bit scared of you when you're standing out there in the car screaming at her?
Objection asked and answered, Your Honor.
I think that's some sustained objection. I think you've asked that a couple of times. Next question, Mr. McDaniel.
So obviously pretty aggressive. She's out there on that day on November 18th. You're actually out there threatening to kill her on that day. You're upset too still. Does that sound kind of a little bit accurate? It wasn't this peaceful
I was
talk.
pretty upset because, I mean, family fights are not nice.
They are not nice. And I'm just trying to get out the truth. I'm just trying to get out the truth. And the state says, and I'm gonna go back to what they said, that you said, do you want to talk together and talk this out? That's not what was said on that November 18th, was it?
When I was in the truck, I said, if you want to talk, we can talk.
There was threats on that night also. Is that correct, ma'am?
I don't recall. I mean, it's a pretty heightened incident when you hear gunshots start firing and you're.
Gunshots were after all that though. Yeah, I do realize it was a heightened incident for everybody.
Yeah, because I mean, it was the incident where I pull off the road and I hadn't even made it off the pavement yet. She's already waiting at her door. And I know this lady my whole entire life, so I already knew what that posture meant. She was ready to fight. That was her mood.
A redheaded coming back out of her, I suspect, Tom. And you were in a fighting mood as well. Does that sound accurate?
Your
Not
Honor,
on the
objection
18th.
asked and answered.
No further questions, John.
Okay. So sustain that objection. Any follow-up questions for this witness, Mr. Mitchell?
Yes, Your Honor. Ms. Nichols, you mentioned something about a wreck. When did that occur?
On Halloween night,
What date?
October 31st.
And did you sustain any injuries from that wreck?
Yes, sir. I was crushed and pinned in front of the vehicle.
And I think the jury saw you had like a brace on your left leg. Is that a result of that?
No, I just had my second knee repair in August,
Okay.
but the wreck injured me.
All right. So I just want to clarify one brief thing about the incident on November 11th. When you went over there to Miss Pravat's house and she swung the board on you, where were your hands at that moment?
Just as they are now in my pockets with this same jacket on.
Okay. And to clarify one more time, you never went over there to fight Miss Pravat.
Correct. I wasn't even going for Miss Pravat.
I believe when you were speaking with Mr. McDaniel, there was a comment about burning the house down, and you said to him, yeah, I've been told that before. Who's told you that?
Her son Artie's threatened it, and the day she got out of jail.
Objection. Well, actually, if she wants to bring out Artie, I'm gonna call him as a witness. I can bring it all in.
Or it's already.
Let me get y'all to approach.
Okie dokie. Well, they approach. I looked something up. This witness was asked if it was a fight, and she said, no, it wasn't a fight. It was a tussle. Well, in my mind, they're the same things. And legally, there's no distinction. But if we look at the actual meanings of the word, yeah, a fight implies mutual intentional violence, whereas a tussle implies a brief, low-level physical contact that is not vicious. Fight, you usually have multiple strikes, it's escalated, that sort of thing. So there is a little bit of a difference. However, there's nothing in legal code that defines a difference. So that was just a curiosity of mine. It was an interesting choice of words. So I wanted to look up exactly definition-wise what would be the specific difference. However, I'm not under the impression that she necessarily knew those definitions, but I could be wrong. Lily, first-degree tussle. Maybe. All right, so what are we on? We're on sidebar number 6 now. Excellent. That's outstanding. Well, once again, everybody, welcome to TCF Live. I hope you're having an enjoyable time. Let me know in the chat if you're enjoying this. Let me know, too, if we should look at doing more trials during the live stream. I kind of have to be selective. It's hard to do like the Judge Boyd multi-day ones. I think that would kill the live, although we're working on a program to be able to present such trials here on TCF in another format. So we'll get there. But for these that theoretically, if it weren't for 27 sidebars, should be faster, I could see us doing more of these. If you're interested, just let me know.
So Ms. Nichols, let's go back to November 18th. Night of this incident for why we're here. You said you were the one driving, correct?
Yes, sir.
And it's a standard vehicle. Were you sitting on the left in the driver's seat?
Yes, sir.
Was there anybody in the passenger seat?
My wife.
And what side of the vehicle could you see Ms. Pravat's residence out of?
Out of my passenger side.
The passenger side. So based on what you're telling us, Alexis had a better view of Ms. Pravat's house.
Sure.
All right. And I believe you said that you couldn't properly see if Ms. Pravat had a weapon on her. Is that because of where you were sitting?
Yes, sir, because I backed up. I was trying to back up and talk to her and I couldn't see.
All right. Now, I'm just going to be very direct with these next few questions. You answer them honestly. On that night, did you get into any kind of physical altercation with Jan Pravat?
No, sir.
On November 18th, did you ever intend to bring Jan Pravat harm?
No, sir.
Did you have a weapon on you on November
No, sir.
18th? Did you ever approach Ms. Pravat's house that night?
No, sir.
Other than when you were driving slowly by to get to your house?
That's all, just going home.
And did you even get out of your vehicle on that night?
No, sir.
Just a moment, Your Honor. No further questions.
Nothing, Your Honor. Thank you very much, Ms. Nichols. You can have a seat back in the seating area. Mr. Mitchell, who do you have as your next witness and how long do you anticipate that testimony to take?
It shouldn't take too long. I would anticipate maybe 15 minutes.
Let's go ahead and call that person, then we'll take our mid-morning break after that witness. Who is that, Mr. Mitchell?
State will call Alexis Nichols to the stand.
Alexis Nichols?
Yes. She may also go by Desiree Nichols.
Ma'am, come on up and stand right here, please, by Sergeant Applewhite. And I'm going to ask our deputy clerk, Ms. Williams, to place you under oath.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Just come on around and have a seat if you will, ma'am. Make yourself comfortable. Mr. Mitchell is going to ask you questions first.
Thank you, Your Honor. Good morning, ma'am. Can you please
Good
tell us your
morning.
name?
Alexis Nichols.
And tell the jury a little bit about yourself. Where do you work at the moment?
I work at Stethoscope in home care.
Is that what you were doing on November 18th of 2025?
No, I was the assistant manager at Dollar General in Grand Ridge.
And at that time, you said Grand Ridge. Was that where you were living at the time?
Yes,
Do you remember the address?
6934 Burke Street.
And that is in Jackson County, Florida, correct?
Yes,
Who were you living with?
I was living with my wife, Ashley Nichols, and our 3 kids,
Your 3 children. How old are they?
7, 13, and 14.
And how long have you known Miss Ashley Nichols?
I've known Ashley roughly around 20 years,
And how long, and you said she's your wife? How long have
Yes.
y'all been married?
almost 2 years.
Right. Now, take us back to November 18th, 2025. What were you doing on that day?
On that day, I was at work from around 3 p.m. to around 10:15.
Did you have anyone come and pick you up?
Yes, my wife came and picked me up from work that night.
Ashley came.
Yes,
and picked you up.
Ashley.
What time did you say she picked you up?
About 10:15, 10:20.
So it's dark out at this
It's
time.
dark.
All right. And did you have any plans or were you just heading back to the house?
We were just heading back to the house.
So the jury sort of heard a little bit about the area in which you live. Can you describe where you were living at the time, what the property was like?
We were living on the back of Miss Prevat's property. You have to go around her house down a bumpy driveway to get to our house where we were residing. It's very rough terrain,
And that's the only way in and out.
the only way in and out.
So you said the condition of the driveway is very rough and bumpy.
Yes,
How do you have to drive when you're going over this driveway?
you have to drive slowly.
All right. And I take it you have to pass by Miss Pravat's house.
Yes, you do.
Is that what you and Ashley did?
Yes,
And let me back up just a little bit. So Ashley is driving, correct?
yes.
Where are you sitting?
In the passenger front seat.
And when you passed by Miss Pravat's house, did you see anything out in the front yard?
I seen there was a black vehicle out in the front yard.
The black vehicle, did it belong to Miss Pravat?
No, it's not her vehicle.
Did you recognize who it belonged to?
Yes,
And do you know who it belonged to? Who was that person?
Christy Bassford.
Did you see Miss Pravat with Miss Bassford?
I didn't see Miss Bassford. I seen Miss Pravat in the doorway.
And I apologize, I may have asked that wrong, but you said you saw Miss Pravat in the doorway
Yes,
of her, in her house, the front porch
front
side?
doorway.
Front doorway. And what was she doing?
She was standing postured with her hands on her hips, just staring at us come in to drive.
I apologize. Go ahead.
Oh, no, she was just standing postured with her hands on her hips as we were coming in the drive. She was watching us as we came in. As we went around the house, she went to each doorway and postured the same stance.
And right quick for the jury, if you would please stand up and show them what this stance was. And you could just stand right over there.
Just standing there
At each,
at each doorway.
and where are these 3 doorways?
You have one in the front of her house, one on the side, and then one in the back.
All right, so you saw this, and as you were passing by, did you hear Ms. Pravat say anything?
I heard her scream something as we got to the back of the house, but I could not understand what it was as the windows were up.
What happened at this point?
At that
After,
point, Ashley asked me to roll down the window. We cracked it and she hollered out to Jan, if you want to talk, we can talk. At that time, the back door closed. Few seconds passed, Ms. Pravat came to the door and shots fired off.
And how many shots did you hear?
There were two, and then delayed, there was a third.
And how far away were you and Ashley from Ms. Pravat's house when this happened?
At that point, we weren't even 100 yards from her house. We had kind of backed up to barricade the tree. It was a tree, a side-by-side, a boat, and something else sitting out there to kind of barricade the shots from us to her, like from her to us.
Were you relatively close to her house when the shots fired, or?
Yes, because we were easing around the drive at that time when she screamed something, and my wife asked her, if you want to talk, we can talk.
So, you heard the shots, sort of barricaded. Did you see her fire these shots?
Yes, I did. Out the passenger window, you could see her standing there with the gun, and you could see the fire come out of the muzzle.
So you saw the muzzle flash?
Yes.
And what happened after these shots seceded, after they stopped?
We took off to the house.
Was there anybody waiting for you at the house when you got there?
Yes, our children were home. Our 14-year-old was on the front porch.
And what's his name?
Jacoby Highsmith.
So I take it that they were at the house when Ashley went to go pick you up.
Yes, he stayed there to babysit his two younger brothers while she came to retrieve me from work.
Were you scared at this moment?
Yes.
Were you in fear for your life?
I was, because I didn't know what she was aiming at. I didn't know where it was going to come down at.
Okay. And were you scared for your children?
Most definitely.
All right. So how much time goes by after the shots before you make your way inside?
It was immediately.
Almost immediately?
Immediately.
What was it?
I jumped out of the truck and ran into the house to make sure our children were safe and secure.
Did you call law enforcement when you got inside?
Yes.
Were you the only one that called law enforcement?
No, I was not.
And after you called law enforcement, how long was it until they made contact with you?
About 30 minutes, give or take.
Did you give a statement to them at all?
I spoke with them, but I didn't give a statement. They didn't ask for my statement.
But everything that happened on that night, you have testified to here today.
Yes.
And finally, is Jan Pravat in this courtroom today?
Yes.
Can you please point her out and identify her by an article of clothing?
She's got on red and black plaid shirt.
And once again, Your Honor, witness has identified the defendant.
Again, the record reflected.
All right, just a moment. We'll send to the witness.
Thank you, Mr. McDaniel. I'll go back to that, I guess. Thank you. Alexis, Ashley, does she capable of saying something like, if you want to talk, we can talk?
She is
that really-
capable.
She is capable of that?
Yes.
Okay. And you're saying your testimony was that you drove up and you turned and you never stopped and the gun just went off while your window was down.
We never stopped until she yelled out. And that's when we rolled the window down and Ashley said, if you want to talk, we can talk. At that time, the back door closed. A few seconds later, she came out and gunshots fired off.
So she goes inside, she gets the gun, comes back out. Y'all were still sitting there trying to talk, waiting for her to talk about something. What were y'all gonna talk about?
No, we had kind of eased off, but the gunshots started firing. So she backed up to keep us barricaded from the fires between the truck, between the tree, the side by side, there was a boat. So we kind of was trying to barricade so the shots didn't hit us.
Mm-hmm. So, and your testimony is you could see her and Ashley was sitting right next to you.
She was sitting next to me. Ashley was sitting in the driver's seat. I was sitting in the passenger seat and Miss Pravat was out in the yard on the left-hand side or right-hand side outside the passenger window.
So she was out in the yard. She wasn't on the porch.
She had walked out in the yard off the porch around the second fire.
First ever heard of this. And so what Ashley's seen is not what you've seen. Something you're saying she was out there in the yard then.
She walked out in the yard firing the gun. Yes, sir.
As a neighbor sees a lot of things, especially in rural communities like where you're staying at. Has there been other instances of violence that happened on that property where she was there and seen against you?
Your Honor, I'm going to object. I think it's beyond the scope of her knowledge.
It's way overbroad. On sustained objection, it's too overbroad. There may be certain instances that may be admissible, but that question is inappropriate. Mr. McDaniel.
Has there been instances where you've been running from your house with you and the kids running away from Ashley?
There's been instances where we've had verbal disputes and I've left, but I've never left running from her, running with my kids, no.
So if someone testifies that they're trying to help you because Ashley was chasing you on foot after you and the kids?
She has never chased me on foot. She is incapable of chasing anybody. She's got a broken leg.
When did you get a broken leg?
She's had a broken leg. She had surgery for it October of 23. And she just had surgery again, August of this past year.
Could have happened before that, I guess, couldn't it?
Your Honor,
We weren't
Let me get you
together
to
at that
approach
time.
so we can fix this.
I'll draw it.
It's TCF Live. It's Thursday. Hope you're all enjoying yourselves. If you have just come in recently, we're in the middle of a trial in Judge Mercer's court down in Florida. Long and the short of it, people behaving badly. You've got somebody who was drunk and had a gun and decided it was a good idea to shoot off a couple of rounds into the air because they never come down. Threats, bad behavior, bad relationships, all the kind of stuff you would expect out of a case like this. This is sidebar number 7, I believe. This is the first time we've watched Judge Mercer in a trial. It's enjoyable. He clearly likes his sidebars, though. So we'll hang tight. I've got something else queued up to show you when they go to break. We are in the Wayback Machine just a few minutes on this, so if they do like a 15 or 30-minute break, it won't have to drag out quite that long.
Okay, Mr. McDaniel, whenever you're ready, sir.
Sir. Alexis, is it true she was yelling at the vehicle that she was going to kill her?
No.
It was.
I'm sorry, I didn't know who was yelling. She was yelling who?
I said, is it true that Ashley?
You said she. You meant Ashley. You're asking if Ashley was yelling that she was going to kill Miss Pravat. Is that the question? Okay.
I apologize.
No, she was not yelling that out the window.
It was, if you want to talk, we can talk.
It was, if you want to talk, we can talk. That's all she hollered out the window.
Hollered out the window. November 11th, you were out there, weren't you? Or were you out there on November 11th when the fight occurred?
I actually was not down there until it had already happened. What I seen was when Jan picked the board up.
Let her answer the question. Let her answer. Wait a second, ma'am. Stop, both of you. The attorney's going to ask a question and not interrupt the witness while she's answering, and you're not going to interrupt him in the middle of a question. Okay, so ask a question and don't interrupt her until she finishes, and then, ma'am, let him finish the question before you start answering. Mr. McDaniel, what's your question?
The question was, were you out there on November 11th when the incident of the fight happened? Were you there present?
I was there when it was ending. What I witnessed was Jan picked the board up and hit Ashley in the head with it.
And did you witness as Ashley was leaving, she threatened to burn her house down with her in it?
I did hear her say that, and I also heard Miss Pravat screaming a lot of derogatory, insane things as well.
Okay. All right. No further questions, John.
Thank you, Mr. McDaniel. Mr. Mitchell, any redirect?
Briefly. Ms. Nichols, you said that you saw the third shot, or maybe it was after the second shot, she walked off the porch. How far did Ms. Pravat walk off the back porch?
Probably a good 30, 40 feet.
30, 40 feet? Okay. Now, after Ashley picked you up that night from work, Were you with Ashley the entire time?
Yes,
And while you were with her, did Ashley ever leave the vehicle?
no, not until we got home, going in the house to check on the children.
Did you ever leave the vehicle?
Not until we got home.
Did Ashley ever approach Miss Pravat's house that night?
No,
What about you? Did you?
no,
And finally, did Ashley ever threaten Miss Pravat that night?
she threatened out of anger by saying that she will burn the house down, but other
Oh,
than
no, no,
that,
no,
no.
I apologize. Let me be more specific. November 18th, the night of this incident, did Ashley ever threaten Miss Pravat on November
No.
18th?
Not on November 18th.
Did you ever threaten?
No.
Just a moment. No further questions, Your Honor.
Thank you, Mr. Mitchell. Mr. McDaniel, any further questions?
No, Your Honor.
Thank you, Ms. Nichols. You can have a seat back in the witness area, and we'll call you as soon as we know more about whether you're going to testify again or not. Ladies and gentlemen of the jury, we're going to take a morning recess at this point. I have 10:39 by my clock. As I mentioned earlier, there's some refreshments in there. You may not have noticed this. I'm a little bit on the pudgy side. And if you don't eat those snacks, you know who's going to. Me. So help yourself, make yourself comfortable. We're going to say 10 minutes. We'll try to start back in roughly 10 minutes. Ladies and gentlemen, please remain in the courtroom while the jury exits for
Okay, again, we're a little bit in the Wayback Machine, but I'm going to take us to a Judge DeSanto hearing real quick while I get us forwarded to the next thing. But I wanted to share something super funny with you. So while this has been going on, I've been typing out different things that we've heard from the lawyers or the jury or stuff like that into one of the AI models that I use. And then I asked it, based on everything I've just given you, where is this trial taking place? And it asked me one question. It said, have you heard asked and answered yet? And I said, yes, we have. And it just came right back and said, Florida. So Florida has a feel that is so ingrained that even the large language models have picked it up and know exactly where something is taking place just based upon the language that's used. And the only clarifying question it asked was, have you heard asked and answered yet? So I just thought that was hilarious. I don't know. But let's do this DeSanto thing while I get us forwarded past the break here.
Not a fact, that was a point.
Morning, Your Honor. Your Honor, John Gold, P 30758, with respect to incidents between your name on the record.
Nicole Weems. Okay, thank you. And today's date scheduled for probation violation on your client's case on 25410A. And then it's set for sentencing on your client's plea to an amended charge of operating while visibly impaired, which was reduced from a high BAC on case number 251269. And counsel,
Your Honor, as to the probation violation, I have discussed it with Ms. Weems. In fact, we discussed this at the time of the entry of the plea on the 2069. The violation is that she picked up a new case while on probation. She is guilty. But you're sentencing on that matter. And we'd ask that the recommendation be adopted.
okay, so, is this something that your client may be interested in a treatment court, counsel? Have you spoken to your client about that?
No, we have not.
Because we could There could be both referred over there. There's not as much time on her original charge, on the 25 case. However, or the 410 case, your client's on probation for possession of controlled substance, and then she picks up a charge for high BAC at a 0.184.
That is
And one of the conditions is not to possess or consume any alcohol or drugs unless prescribed. And, is that?
You're right. I think that she has been going over probation here with this court regarding the original matter. She's also been very cooperative in understanding that I've spoken to Miss Shine previously when the violation as well as the sentence report was provided to me.
Okay.
Taking all those steps, she's got a new job. I feel that at this point in time, Your Honor, I don't think that she realizes that you cannot use any type of mind-altering substances. She, everything she's supposed to, respect to previous sentencing, other than picking up the new case, and I understand that. I'm not making light of that. I don't see that the specialty court would be appropriate under these circumstances.
Okay.
I mean, that's,
Given that your client's on probation for a possession charge and then she picks up a high BAC charge, I thought that perhaps there might be something that she wanted to explore regarding, sobriety court. But okay, as to this, let's handle the sentencing first. As to the PSI counsel, do you have an opportunity to review the PSI with your client?
that is correct, Your Honor. There were no additional deletions or corrections made at this point in time. As the report indicates, she's presently employed at E-Funds in Southfield as a life insurance agent. That's a new job that she's been with now. How long?
Like 2 months.
Approximately 2 months. Clearly, she's trying to better herself. Is taking all the steps necessary to do all that. She's been clean on her other probation matters. There are no other violations. In other words, she's not missing tests. She's not testing positive for any controlled substance. She's on an alcohol tether at this point, and there have been no violations on that as well. We're asking the recommendation be adopted.
And so tell me about your warrants, ma'am.
The warrants that I have through Wyandotte still, I've been working on paying for my probation fees and paying off those slowly as much as I can.
What's the status of your driver's license?
It's valid, but it's restricted due to the OWI. So.
Okay. Well, there aren't any warrants in Wyandotte. Do you have a warrant out of Novi for failing to appear for retail fraud sentencing?
Oh, I wasn't aware of that one. Is that old? Does it have a date on it?
2020.
Oh, okay.
You don't remember anything in Novi? You don't remember pleading to a case in Novi?
No, I never went to court.
You never went to court?
No, that's Novi. But I can take care of that too if I'll go down there and see what.
Well, this appears to be you. You don't remember being charged for shoplifting from 2018?
No, I never went to court for anybody.
Well, it claims that you didn't appear for sentencing, so at some point you must have attended court to plead guilty.
Right, I'll have to look at, I'll take care of that one. I wasn't aware of that one.
Okay, and then you also have one out of the 34th District Court for something from Van Buren Township.
Okay.
You failed to appear for driving while license suspended. So there may only be 2 warrants, not 3. If you're a test right now, ma'am, what's in your system?
Nothing.
And how old's your son? 7? Yes?
Yeah.
Okay, well, you really need to get all these taken care of, ma'am, because you certainly don't want to be arrested when you have your son in the car.
Right.
So. All right, as to the charge of operating while visibly impaired, the court's going to find, after hearing from counsel, hearing from Ms. Means, reviewing the report, the recommendation that there is reasonable grounds to depart from MCL 769.5. The court's going to also order that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Weanings. The court's going to order 18 months probation. You're eligible for early discharge. I'll go over that shortly. Some of these are going to sound familiar since you're currently on probation and the court sentenced you to some of that already. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to order you to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can have assistance in providing coping mechanisms so you can maintain sobriety and prevent relapse. The court's going to also order you to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. You're to participate in the fan meetings once per month. The rehabilitative goal for that condition is so you can have additional support in maintaining sobriety as well as recovery resources. The court's going to also order 7 days on the court workforce. The rehabilitative goal for that condition is so that you can further develop life skills to give back to the community and you are to clear up your warrants. Any questions as far as those conditions? Court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Workforce is $280. That's $50 a day, $40 a day at 7 days. For a total of $2,005. You did post a bond, so you can apply that bond. You can work out a payment plan through probation. And I did indicate you're eligible for early discharge as long as all the following apply. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations and all monies have been paid in full. Or you made a good faith payment for making full payment. So let's handle the probation violation now. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the allegation, ma'am, and as to the allegation that you violated probation with your charge that you were just sentenced on, how do you plead?
Yes.
You've gone over your advice of rights for probation violation purposes, correct?
Yes,
And you understand all of those rights.
yes,
You also understand by entering into a plea that you'll be waiving some of those rights.
yes,
You understand the possible penalty as a result of your plea. The recommendation is for you to continue and complete all terms of probation, have under advisement status revoked, pay a $50 probation violation fee, and additional workforce days, increased testing, and 10 days jail. You understand that's the recommendation? Knowing all of that, do you want to continue with your plea?
yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? I'm sorry?
No.
All right, counsel, if you can please pardon your client.
Thank you. Ms. Weems, you were placed on probation to this court. Is that correct?
Yes,
And one of the terms and conditions of probation were that you were not to pick up any new matters. Is that correct?
yes,
And in fact, you did pick up another matter, and it was actually in this court as well. Isn't that correct?
yes,
Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And not only were you not to get violate any criminal law of any unit of government, but you also were not to possess or consume any alcohol or drugs that were not prescribed, correct?
yes,
All right. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. Counsel, as to the recommendation.
Your Honor, other than the revoke of her under advisement status, I have discussed that recommendation with her. She understands the severity of what occurred, and we're asking that the recommendation be adopted, except for the fact that she loses her under advisement status. There is no, and we've indicated, there was no, she picked up a new case which dealt with alcohol, and I agree. She has been going to her classes. She's been taking care of all business on that matter. She's been on an alcohol tether for a period of time. We feel that she did not lose her under advisement status at this point in time.
Why not?
Because, Your Honor, this was a slip. She now being punished for her consumption of alcohol as well. And for those reasons, Your Honor, it will even do a greater, as you heard, her driving privileges are restricted to from court, et cetera. And if this under advisement status is revoked, then she'll be losing her driving privileges for a period of time because this was a drug-related offense. And she just got a new job. Has children, child that she has to take care of. And the loss of her license at this point in time would only create, it's our own fault, further hardships to successfully completing both terms of court.
Okay. So let me ask a few questions, Ms. Weems. You recall at sentencing on your possession charge that there would be mandatory jail for any violations, correct?
yes, I do remember.
And in fact, you received that in your written order of probation.
Yes,
And I also understand that you lost the other job when you were in custody, correct?
yeah.
So then knowing all of that, ma'am, why would you risk any of that and violate probation?
Yeah, I just don't, I really don't want to lose.
That wasn't my question. That wasn't my question. My question is, why would you jeopardize that?
I definitely made a mistake. I didn't mean to. It won't happen again, but I don't want to hear again. I don't want to do this again at all. And I definitely don't want to lose the job that I have now. It is very good. It's a good job. It's good people, good pay. I want to be able to pay my fines to the court.
And all that's great, ma'am, but you're still not answering this court's question. Why did you jeopardize your status and violate probation. And you didn't just, wasn't just a slip, right? Because you consumed a lot of alcohol. You were 0.18 something. That's a lot of alcohol. It isn't just one slip where you forgot to call for drug testing or, you know, you had a sip of somebody's drink or something like that.
Right.
You consumed a lot of alcohol.
Right.
You made the conscious choice to violate this court's order and jeopardize your freedom. Why would you make that choice to jeopardize your freedom?
Because I don't really have a better reason other than I was just being stupid. And I don't plan on doing it again, but it was very stupid and I was just not in a good place and being stupid.
Well, your probation officer has a much more bleeding heart than I do, because your probation officer is recommending to suspend the jail.
Yeah.
Despite this court's order indicating mandatory jail for any violation. And I also, when I sentenced you in May, ordered you to clear up your warrants. And we're 9 months into your probation and you haven't done that yet either.
Yeah, I wasn't aware of the November. I'll take care of that one for sure. I got the Allen Park ones taken care of. I know that was some of the ones I had. And then the Van Bureau one I can do as soon as I get paid again.
If you were to test right now, what's in your system?
Nothing.
And is it just you and your son that live at home?
Yeah.
Yes?
Yes.
The court will suspend your 10 days jail. You are to have additional days on the workforce. You're to increase your testing. Do you currently have a tether?
Yeah.
A $50 probation violation fee. You'll continue and complete all terms of probation. The court will continue your under advisement status at this point. If you are back in front of this court for a violation on either of your cases, ma'am, you can be sure of one thing. Well, two things. You will be serving jail time and you will be losing your under advisement status.
Understood.
Going to also order 30 days on the alcohol tether. So while it may be ending on the matter you're just sentenced on, you will have it on the probation violation. I'm not going to add workforce days.
I'm sorry.
I'm not going to add additional workforce days.
Okay, thank you.
Tether instead.
Thank you, Rob.
Increased testing. Okay, ma'am, please have a seat in probation, and Ms. Shine will be with you shortly.
Thank you, Your Honor.
Good luck to you. Let's go off the record for a moment.
Okay, friends, I was just getting stuff arranged here because while this hearing was going on, so in Wade Mercer's court, and we'll go back to it, they come back from...
Yeah, okay.
Hush up. They come back from break, but then he actually cuts the feed for a minute, it looks like, and then restarts it. So anyways, we're going to pick up when they come back from break, see what the cutting of the feed was all about, and then we'll go to the fresh one that he's got. So again, back to the Judge Mercer trial.
This place is warm in here.
Yeah. All right, we're back on record. Everyone's back in the courtroom except the jury. We've got Mr. Mitchell, Mr. Gill, Mr. McDaniel, Ms. Pravat. So Ms. Pravat, as well as the two ladies on the second row over here, you're distracting me and the jury by your head movements and shaking your head. I couldn't care less if you disagree with something a witness says. You can't be demonstrative in that disagreement to the extent that you are distracting those of us trying to pay attention. So a young lady on the right here, I think the bailiff had said something to you the first time it happened during Mr. Mitchell's opening statement. And Ms. Pravat, if you disagree with them, that's fine. But you can't be making all these head gestures and hand gestures. It's very distracting. So try to watch that, please. Mr. Mitchell, are you ready to bring the jury back in?
Very briefly.
Very briefly.
Hold on. Do you want to address?
There was an issue with the video, Judge. I think that we might expedite something if the court wanted to hear this. We might have a remedy to kind of help the court roll on some stuff.
So tell me what the issue is and how.
So this is harping on the issue when it came to the edited version showing the interior of the house.
Okay.
We have 3 still shots that accurately represent the body camera that the state intends on playing that shows the interior of the house, if that would help the court decide on, you know.
Judge, I think the objection by the defense is very narrow. He doesn't like the condition of the home. We have photographs taken from the body camera that show the condition of the home that the court can look at to see if the court wants to make a ruling on that. If not, we're happy to play the video. We have 2 videos ready to go. We have the one that is the condition of the home is taken out, and we have the one that's ready to go with the home in on the body camera.
You're asking to introduce a video that shows the condition of the home into evidence.
Yes.
And your objection is that the condition of the home is unfairly prejudicial. Explain, please.
Yes, Your Honor. I just don't see no value in the condition of the home, and that's what I mean, I'm not saying they're purposely trying to do it. I guess they're trying to tell me now that they want to see where they found the gun at. But like I said, the deputy can tell them where they found the gun. I don't see the issue of, where he's walking into the house there.
Do you have an objection to me making that ruling on the admissibility of that video based upon these still photos, or do I need to see the video to fairly and accurately rule on that?
Pictures and make a.
Okay,
the pictures are going to show what the house looks like, and I just don't want to embarrass her on YouTube, Your Honor, and showing. That's what it boils down.
That's a different issue totally. Whether we go off YouTube for that part of the video is a different question.
Yes.
Okay, so we're going to call these states exhibits number 1, 2, and 3 for identification. You said 3 photos, correct?
Yes, Your Honor.
So just for identification purposes, for the limited purpose of what we're trying to do here, let me see the pictures, and then we'll hear any argument in regards to those pictures, since both sides agree that.
And y'all think that it's important because, I guess, just to say where he found
And I'll go ahead and give them that instruction for when the time comes, if you don't have any objection to that. It's the standard when it comes to edited recording. Okay.
So on the video, these pictures are just in the background.
Yes. Taken from the body camera that state intends to introduce.
Okay, so I'm looked at the 3 pictures, states exhibits 1, 2, and 3 for identification purposes only, not admitted into evidence. And they show a home that is, I would say, mildly cluttered. That's how I would describe it. They are what they are. So any further objection on the record, Mr. McDaniel?
Yeah, what was the purpose? It's just, y'all would have just shown
John, I mean,
where the gun was found at? I mean,
Your Honor, the state intends to play the video. It shows where the firearm was located by law enforcement, where it was sitting, where the back porch is in relation to where the firearm was located. It shows a lot of spatial issues. It's relevant. It gives the jury information that they can use to rely on in the case.
Mr. McDaniel, anything else? Nothing, Your Honor. I'm going to overrule the objection based upon the video, the photos I've seen, and determine that those photos, as long as they're not 20 minutes or even 10 minutes of just video in the house, and it's just ancillary or ancillary, and it's not so prejudicial or inflammatory that it's going to inflame the jury. Okay. So any other issues we need to resolve before we call the jury back in, Mr. Mitchell?
No, Your Honor.
Anything from the defense?
No, Your Honor.
Who is your next witness? Let's go ahead and get them in here.
Going to be Jacoby Highsmith.
Jacoby Highsmith, please.
We're looking at time and it shouldn't take too long. For
James, will you make sure that none of the jurors are in the restroom, please? Let us know if they're ready.
Jakobe.
They're all in there. Go ahead and bring the jury in then, please. Mr. Highsmith, just come stand up here by Sergeant Applewhite.
You're in the courtroom.
Just stand right there, Mr. Highsmith. All right, ladies and gentlemen, we have our jury back in the jury box. Mr. Mitchell, state prepared to call their next witness.
Yes, Your Honor. State will call Jacoby Highsmith to the stand.
Mr. Highsmith, I'm going to ask the clerk to place you under oath, and then we'll get you to have a seat in just a second, okay? Mr. Highsmith, just come on around and have a seat. I'm going to ask that you make yourself comfortable and get that microphone. See, this microphone's probably within 4 to 6 inches of my mouth, so pull that microphone up to you and speak loudly and clearly into the microphone, please, so that everyone can hear your answers. And Mr. Mitchell's going to ask you a few questions first. Mr. Mitchell?
Thank you, Your Honor. Morning, can you please state your name for the jury?
Jacoby Highsmith.
And Mr. Highsmith, can you tell us how old you are?
14.
And are you currently in school?
Yes, sir.
What grade?
7th.
What school do you go to?
Mariana K through 8.
Do you live in Mariana?
Yes, sir.
Did you live in Mariana on November 18th, 2025?
No, sir.
Where did you? Hang on just a second. Let me get y'all to approach, please.
Okay, right there is where he cuts the feed, but he's got another one, so we're going to go back there and see what we missed. I don't know if maybe it's because of the kid's age that he was trying to avoid that testimony being streamed or what. No idea, but right here is where he picks up again.
All right, State is calling Deputy Ryan Grover. Deputy Grover, if you'd please stand and let me get you to raise your right hand. The clerk's going to place you under oath.
So yeah, based on the fact that they went right to another witness, I think that's what happened there. They cut out the 7th grader's testimony. So there we go. Let's pick up.
Just whenever you're ready, Mr. Mitchell.
Thank you, Your Honor. Morning.
Good morning.
Can you please state your name for the record?
Deputy Ryan Grover,
And Deputy Grover, where are you currently employed?
Jackson County Sheriff's Office.
How long have you been with Jackson County Sheriff's Office?
Approximately 2.5 years.
Do you have any other experience with law enforcement prior to your service with JCSO?
No, sir.
And back on November 18th of 2025, were you employed with Jackson County Sheriff's Office?
Yes, sir.
Were you in uniform that day?
Yes, sir.
Were you on duty that day?
Yes, sir.
And was your uniform equipped with a recording device or a body worn camera?
Yes, sir.
And now I'll just ask it. How did you first become involved in this case?
We received a call from dispatch in reference to a shooting in the area towards the end of Burke Street. And we were dispatched to the call, myself and Deputy Swift.
Okay. And you said Burke Street. Do you remember the exact address?
6931 Burke Street.
And what city was that?
Grand Ridge, Florida.
And that's in Jackson County, Florida.
Yes, sir.
So about what time did you receive this call?
Sometime after 10 p.m.
Were you by yourself?
No, sir. I had Deputy Swift with me.
Oh, I apologize. You already said that. And you said the complaints were of shots fired in the area.
Yes, sir.
So when you arrived at the residence, who did you first make contact with?
Christy Joe Basford.
Who is Christy Joe Basford?
She was a subject that was on scene sitting in the back of a vehicle in the front yard.
Okay. And was she the one you were looking for?
No, sir.
Where was the alleged suspect you were looking for?
Inside the home.
Did you make contact with that person?
Yes, sir.
And did you find out her name?
Yes, sir.
What was her name?
Jan Privat.
And I guess we'll go ahead and ask this question. Is Jan Privat in this courtroom today?
Yes, sir.
Where is she? Can you point to her and identify her by an article of clothing?
Yes, sir. Right there. Black shirt, red and black plaid jacket.
Looks like plaid.
Yes, sir.
And once again, Your Honor, let the record reflect, witness has identified the defendant.
You don't have to continually do that. Once a witness does it for the record, that's sufficient. You can ask the jury to take notice of it, but the record doesn't need to reflect it anymore.
All right.
Next question.
Just making sure, Your Honor.
Sure.
All right. So upon making contact with Ms. Privat, what was the first thing you noticed about her?
She was stumbling her words, talking a lot.
Now, when you say she was stumbling over her words, what do you mean by that?
She was slurring her words.
Oh, slurring.
Yes, sir. Signs that are indicative of intoxication by alcohol.
And do you have any training when it comes to, let me ask you this way. Have you received any experience and training when it comes to conducting DUIs?
Nothing further than basic in the academy.
But in the academy, they teach you how to, in the academy, do they teach you how to examine and observe signs of intoxication?
Yes, sir, along with standardized field sobriety tests.
And did you observe some of these indicators?
Yes, sir.
And I think you already mentioned slurred speech. Did you observe anything else?
Yes, sir. Watery eyes, the odor of alcohol was present.
Right. So after you make contact with her, what did you do next?
I believe she was detained.
You detained her?
Yes, sir.
What was the reason for detaining her?
To further investigate the crime.
Was there an issue of officer safety?
Possibly due to a firearm being associated with the call.
All right. What happened after she was detained?
She was read Miranda by Deputy Swift.
Okay, so you didn't read her Miranda rights?
No, sir, but I was present.
And you heard her be read the Miranda rights, correct?
Yes, sir.
And did you hear her acknowledge them?
Yes, sir.
Did she agree to speak with
Yes,
law enforcement? And well, what did she say about this incident after she was Mirandized?
She did admit to firing the weapon, stated that she was not scared of Miss Nicole. Miss Nichols. I'm sorry.
Okay.
Miss Nichols.
I'm sorry, my hearing is kind of bad, so
Yes, sir.
sometimes I have to reassure. But she said to you that she admitted to firing the weapon and that she was not afraid of Miss Nichols. That's what you said?
Yes, sir.
Okay. Did she tell you what kind of firearm it was?
Not initially, I don't believe.
Did she tell Deputy Swift?
Possibly.
All right. Were you the one to retrieve the firearm?
No, sir.
Who did retrieve the firearm?
Deputy Swift.
Did you wait with Miss Privat while Deputy Swift retrieved the firearm?
Yes, sir, I did.
Do you know where the firearm was?
Inside the residence.
All right. So you waited with Miss Pravat while he retrieved the firearm?
Yes, sir.
How long was this, let's call it one-on-one interaction that you had with Miss Pravat?
Maybe a minute and a half.
Minute and a half?
Yes, sir.
And during these, I'm going to call them 90 seconds. During these 90 seconds, did you ask her anything?
Yes, sir. I asked her to show me where the truck was and where Miss Nichols was driving by whenever she fired the weapon.
And did she actually show you?
Yes, sir.
And she showed you. Did she walk you over to where it occurred?
Yes, sir. She walked me over to the driveway on the side of her house.
Did she tell you where she shot the weapon from?
She stayed at the back porch or by the back door.
Right. And this entire interaction, the 90 seconds, was captured on your body worn camera, correct?
Yes, sir.
All right. Your Honor, may I approach the witness?
Yes, sir.
Deputy Grover, I'm showing you what's been marked as State's Exhibit A. Do you recognize what I am showing you?
Yes, sir.
And what is it that I'm showing you?
The version of my body worn camera.
Okay. And have you had a chance to review the contents of your body camera?
Yes, sir.
And does it fairly and accurately depict your interaction with Ms. Pravat on November 18th, 2025?
Yes, sir.
Your Honor, at this time, the state will move to enter State's Exhibit A into evidence.
Mr. McDaniel, any objection?
No objection.
State's Exhibit A will be admitted into evidence.
All right.
Mr. Mitchell,
And Your Honor, the state will be requesting permission to publish.
granted.
I'm gonna need PC. Actually, before we play it, we're requesting the instruction be read, 2.2.
Thank you. Any objection to this instruction, Mr. McDaniel? Members of the jury, you're about to view and listen to a video and audio recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and listen to and consider the evidence. Typically, these recordings may be very long, so it's been edited, but the portions that you're not seeing are not relevant. Mr. Mitchell.
Thank you, Your Honor. Yes.
It's the middle of the night, and we're getting calls, from a bunch of different people. We're waking up people in the neighborhood. Hey, someone's shooting down here. Someone's shooting down here, right? So this is where we're coming from. We have to make sure there was no ill intent with it. It wasn't aimed at anybody.
I shot it in there. I didn't want to hurt her. I would come in here and lock these doors. So she's fucking crazy.
You did lock the door.
She's crazy. I come in here and lock the doors. I said, if she gets through one of these doors, I will shoot her.
I understand. So we just have to go through our processes to make sure no crime was committed and things like that. Okay.
Yeah.
Where was she at when you shot?
That she was going down the road. She said, bitch, I'll kill you, bitch.
So she drove by right here saying that. When you shot.
She's hollered at me.
Okay.
And then she hit the goddamn.
Okay. When you shot, where was she at? She already down there is what you're saying?
No, she was going and I just shot up in there. I didn't shoot.
But she was already driving back there?
Yeah, she was driving by.
She was back there?
But see, she talked to me the other day. She jumped on me.
Was she like next to you or was she already back there?
No, she was in the truck. I had eight.
Saying where was the truck? Was it next to you or was it further down?
Look here.
Okay.
Come here. Let me show you.
You showed me where everything happened.
I ain't never been in goddamn handcuffs before.
I understand.
I ain't never been in them.
I understand.
Hey, I tried to do the right thing.
Where was it at? Where were you?
Way down there.
Now, Deputy Grover, I'm going to pause it right quick because I want to bring something to your attention. That driveway right there that you can see in your body cam, is that the only driveway that you were able to take to get to Miss Pravat's residence?
To Ms. Pravat's?
Well, I apologize, Miss Nichols's residence.
Yes, sir.
And based on your observations of what you experienced that night and what you see in the body cam, how would you describe the condition of that road?
Very bumpy and unkept.
And we can see what looks like ditches or maybe divots in the road.
Yes, sir.
Okay.
Around that tree.
She was way down there?
Yeah.
Okay, where were you standing at?
I'll get you.
Where were you standing at when you shot?
Out my back door.
Out the back door, back here?
Yeah.
Okay.
Like you said, about 90 seconds that you interacted with her.
Yes, sir.
So after your 90-second interaction with Ms. Pravat, did you continue asking her questions?
I can't recall.
What about Deputy Swift?
Yes, sir. He
Okay,
did.
so I guess it's your testimony that after that, Deputy Swift took back over.
Yes, sir. And they began questioning her about the firearm and ammunition.
And you were with Swift the entire time?
Yes, sir.
Did you collect any more statements?
No, sir, but Deputy Swift did.
All right. And you ended up making contact with Ashley Nichols, correct?
Yes, sir, we did.
Was Swift also the one that collected these statements?
Yes, sir, he was.
All right. And after Swift collected statements from Ashley Nichols, did that conclude your involvement in the investigation?
Yes, sir.
All right, just a moment. I apologize. We'll tender the witness.
Thank you, Mr. Mitchell, Mr. McDaniel.
Thank you.
Do you need that bond case? We can take it off.
Mr. Grover. Interesting night, I guess, that night, huh?
Yes, sir.
Was there anything that made you to believe that she used the weapon in a reckless manner? In other
Yes.
words, she told you that she pointed up in the air and shot it. Was there anything different than that?
Other than her being intoxicated, no, sir.
Okay. Other than her being intoxicated, but she was able to hold the weapon and shoot it up in the air by all counts, and
Yes,
she,
sir.
she may have been drinking. I understand that. But that it's not illegal to have a weapon and drink, is it?
You cannot fire it and while you're intoxicated.
That's not actually true, though, is it? You have to be, your normal faculties are impaired.
Yes, sir.
Okay. So do you know what her normal faculties are?
No, sir.
Okay. So you agree you'd have a hard time determining if her normal faculties may have been impaired if you don't know what her normal faculties are?
Possibly.
Okay. You don't know her medical history. Would that be accurate to say? You didn't ask her any kind of questions, whether she had diabetes, you didn't ask her any of those type of questions or didn't do any kind of DUI test to see how much alcohol was in her?
No, sir. We did not.
I know she was very excited and it probably come across that way. It might surprise you that she's like that all the time, I suspect, but you may not know that. Was she very cooperative?
Yes, sir.
Assisted you in every way she could?
Yes, sir. We asked her if we could retrieve the firearm from the house and she stated we could do whatever we wanted there.
Sometimes in the legal community, we look for magic words and you're in the legal community. When someone says they're not afraid for their life, that means at that point in time, you kind of take off the burden of basically any kind of self-defense. Is that correct? And she said that she wasn't scared of her.
Yes, sir.
Okay. So when you got there, her door was locked, wasn't it?
Yes, sir, it was.
You would have no idea whether she normally locks her doors or not, would you?
Correct.
In your experience and as you were viewing her, did she look scared?
No, sir.
Did she look scared at all?
No, sir.
Did she sound scared?
No, sir.
She's none of those things we just watched. Didn't sound any kind of. She mentioned to you about an incident that happened a week prior. Did you hear that?
Yes, sir.
And you kind of brushed it off because she had said she wasn't scared. Does that be an accurate description?
I can't recall.
Okay. So you didn't take into account any of those things that happened prior then, did you?
No, sir.
Again, though, is it reckless to hold a gun up in the air and shoot it up in the air?
I guess it just
It
depends.
is, a lot of police officers be in jail. I think we'd agree with that, correct?
I guess it just depends on circumstances.
Depends on circumstances. Okay. I don't have any other questions, John. Thank you. Yeah.
Thank you, Mr. McDaniel. Mr. Mitchell, any redirect?
Briefly. Deputy Grover, you said you received your training when it comes to determining signs of impairment in the academy, correct? Yes, sir. Does the academy teach you how to see if normal faculties are impaired? Teach you to look for certain indicators, such as slurring of speech, trouble maintaining balance, watery eyes, bloodshot eyes, things of that nature. And those indicate, and based on your training experience, those indicators play a factor in determining whether or not normal faculties are impaired. Yes, sir. And based on your training experience and your interaction with Ms. Pravat that night, did it appear to you her normal faculties were impaired? Yes, sir. Right. Let me ask you about this. I believe Mr. McDaniel asked you if it's reckless to fire a weapon in the air. Briefly, can you tell us what the dangers are of firing a weapon in the air? What goes up must come down. Simple way to put it. And is it reckless to fire a weapon in the air while your normal faculties are impaired? Yes, sir. And there was another individual on scene in the same residence. And who was that individual again? Christy Joe Bassford. Just a moment, Your Honor. Finally, is it reckless to fire a weapon in the middle of the night when there's no light source around you? Yes, sir. It's not common. No further questions, Your Honor.
Okay, thank you, Mr. McDaniel.
What's reckless about shooting a weapon at nighttime? I shot weapon. Is that an act in itself reckless?
I'm sorry, I can't hear you.
Is that act in itself reckless, shooting a weapon at nighttime?
It's harder to see your surroundings at night to be aware of where the bullet may fall.
Someone shoots a weapon at nighttime is reckless.
Yes, sir, it could be.
Okay, all right. So again, I'm gonna go back to, he asked you these questions about your training and stuff. You're not a doctor, are you, Deputy?
Sir?
You're not a doctor, are you?
A doctor? No, sir.
No. So, and you didn't ask her any questions about what kind of medical conditions that might be causing that?
No, sir.
Take a look at her real close in the eyes right now. She's got glossy eyes, don't she? Yeah, watery eyes. Same things that you said. Could that be because of atrial fibrillation, congestive heart failure, high blood pressures, diabetes? Any of those things could be causes of that?
I'm unaware.
You're not a doctor. You're not sure though, are you?
Objection, Your Honor. He's not a doctor.
That's what I'm getting to.
Okay, sustain the objection. Go ahead, Mr. McDaniel.
Thank you. So, but you didn't ask about any of those things though, did you?
No, sir.
Okay. And you didn't do any kind of testing on her to see if she normal faculties were impaired?
No, sir. We don't typically conduct standardized field sobriety tests on a scene other than a DUI.
Okay. Now, she seems to be, I mean, I watched the entire video, and I mean, I don't want to make the jury watch the entire, go through everything, but she never falls down. I don't ever see her. You mentioned that she was swaying. I mean, for an elderly woman in her upper 60s, I didn't see her swaying. I mean, it was just, she had handcuffs on behind her back, and she was still able to walk out into the yard and walk around. Did she fall down on you at any point in time?
No, sir, she did not.
So her normal faculties would be able to walk, talk, and you said that she was slurring. Could her congestive heart failure be also affect that?
Sustain, unless you can show a basis that he even knows the effects of congestive heart failure, he can't answer that question unless you establish a basis first. Next question, Mr. McDaniel.
Be safe to say this whole charge is based on that y'all smelled alcohol.
One of the charges.
Okay. Thank you. Nothing else.
Next witness, Mr. Anything else from this witness, Mr. Mitchell?
No, Your Honor.
Okay, and can my Deputy Grover be released? Does anybody intend to recall him possibly? Deputy Grover, you're through. Your testimony is complete. You're free to leave and get back to the office. If you're working today, you're also free to watch the rest of the trial if you want to. You're not going to be recalled. Have a good day, sir.
Yes, sir. Thank you.
Thank you. Next witness, Mr. Mitchell.
Our next witness will be Deputy Michael Swift. Yes.
Deputy Swift, we're going to ask our deputy clerk to place you under oath, and then we'll get you to have a seat in just a moment.
Swear or affirm that the testimony you are about to give will be the truth, whole truth, and nothing but the truth.
Please have a seat in that witness stand. Make yourself comfortable. And Mr. Mitchell's going to ask you some questions first. Mr. Mitchell.
Thank you, Your Honor. Wait till he gets comfortable. Good morning. Could you state your name for the record?
Michael Swift,
And where are you currently employed?
the Jackson County Sheriff's Office.
How long have you been employed with, I'm going to call him JCSO?
Yes, sir. About 4 months now.
Do you have any other experience in law enforcement prior to your service with JCSO?
I do, yes, sir. I worked at the Panama City Beach Police Department for a year and the Gulf County Sheriff's Office for 2 years.
Okay. And back on November 18th of 2025, were you employed with JCSO?
I was, yes, sir.
And standard questions, were you on duty that day?
I was, yes, sir.
Were you in uniform that day?
Yes, sir.
And was your uniform equipped with a body-worn camera device?
Yes, sir, it was.
All right. So how did you first become involved in this case?
We received a call for service in reference to shots fired in a residential area in the 6,000 block of Burke Street.
You said Burke Street. Do you remember the exact address?
6934 is what is in the CAD.
All right. And what city is that in?
Grand Ridge.
And is that in Jackson County, Florida?
It is, yes, sir.
All right. So what time did this complaint come in?
I believe per the report, I responded at 10:33 p.m. It looks like the call came in at 10:30 p.m.
And I see that you have your report there and you're referencing
I do,
that.
yes, sir.
Okay. So once again, what were the complaints in regard to?
Shots fired in a residential area allegedly toward individuals.
And did you make your way to Burke Street?
I was riding passenger in Deputy Grover's patrol vehicle. I was in field training at the time and he was my FTO.
Okay. What's FTO again?
Field training officer.
Okay. And when you got to the residence, who did you make contact with?
Initially, Deputy Grover and I made contact with Miss Jan Privat at the front door after knocking on the door.
Oh, I'm sorry if I interrupted you.
Yep.
So when you made contact with Miss Privat, what was the first thing you noticed about her?
She appeared to be both distraught and impaired.
You said impaired. How can you tell she was impaired?
There were multiple indicators of impairment that I am trained to detect through DUI training that I have taken. However, during the call for service, when I was speaking to Ms. Privat, there were the red, watery, bloodshot eyes, the very, very distinct odor of alcohol coming off her breath. The way she was telling her stories was very cyclic in nature. She would repeat herself or make the same statements repeatedly. And I'm just appearing intoxicated.
And you said you've had training in DUIs before. Is it extensive training that you've had?
More extensive than a standard patrol deputy would have, yes, sir.
And what do you get from that training when it comes to DUI cases?
I have been through a secondary DUI training, and then on top of that, I've been through what's called the Advanced Roadside Impaired Driving Enforcement course, and that is a step above just standard detection of regular DUIs. It gives you more hands-on experience. You do more wet labs with more impaired individuals at different levels, and it helps you detect when somebody's normal faculties are impaired throughout a typical conversation with an individual.
And based on your training experience, how would you describe Ms. Privat's normal faculties on November 18th on that night?
She definitely impaired.
All right. So you make contact with her. What do you do next?
Deputy Grover initiated the detainment, but we detained her with hand restraints just due to the nature of the call.
You said due to the nature of the call, was that a safety concern?
It was for scene officer and her own safety, given the nature of the call for service.
Okay. So what do you do after she gets detained?
If I recall correctly, I immediately read her her Miranda rights from a pre-printed card as she was now in our custody, and I was going to ask some questions that would potentially incriminate her.
Do you have that pre-printed card on you?
I do, yes, sir.
If you don't mind, could you please show it for the jury?
So,
and that's the pre-printed card you read to Ms. Pravat.
It is.
And after you read her Miranda rights, did she acknowledge and understand them?
She did.
And did she agree to speak with you?
Yes, sir, she did.
Okay. So post Miranda, what did you ask her?
I asked her, I can't remember my exact wording, but basically if she had fired the firearm.
And what did she say?
She told me she fired the firearm in the air.
Just in the air?
Yes, sir.
Did she tell you what kind of weapon it was she used?
When I asked if the firearm was in the house, she referred to her 38 and told me it was on the kitchen table.
You say 38. Is that what kind of gun is that?
It is a revolver.
Okay. And the jury may understand how it is, but for those that don't, how is a revolver different from like a standard semi-auto pistol?
A revolver is different in the sense that you have to manually reload after you have shot. A standard semi-automatic firearm, such as what we carry in law enforcement, when you fire a round, it automatically ejects the spent casing onto the ground. When you fire a revolver, you can fire all of the live rounds out of that weapon, and all of the spent casings will still remain in the weapon until you manually open the cylinder and remove those casings.
All right. And did she tell you where her 38 revolver was?
Yes, sir.
And where was it?
On the kitchen table.
Did you ask her if she had reloaded it or,
I did. Yes, sir.
And what did she say to that?
She wasn't sure. She didn't know. And she gave me multiple answers in regards to that question.
You said multiple answers. What did so she said, I don't know at first. What'd she say after that?
I don't know, maybe.
So she couldn't give you a straight answer.
Yes, sir.
So did you ask her about the other person involved in this incident?
I would have to refer back to my body cam footage. I don't explicitly recall if I asked her about the complainant, but I believe I asked her why the incident transpired.
Did you mention a person by the name of Ashley Nichols to her?
Yes, I did.
And did she tell you who Ashley Nichols was?
I don't remember the exact type of kin, but she did state that she was a family member.
Okay. And did she say anything about Ashley Nichols?
She claimed that she was on probation. She used some vulgar language and stated that that Miss Nichols, she was referring to prior incidents, stating that about a week prior, I guess law enforcement was contacted and she wanted Miss Nichols removed from the trailer that she was staying in.
All right. Did she tell you about if she was afraid of Miss Nichols?
On the contrary, she actually said that she was not afraid of Miss Nichols.
She said she was not afraid.
Correct.
All right. So you get these statements out. And after that, did you go and retrieve the weapon?
I did after obtaining consent from Miss Pravat to enter her residence.
She gave you consent to enter the residence?
Yes, sir.
Where was the weapon located?
The firearm was located in a multicolored bag. It appeared to be like a hygiene bag, and that was sitting on the kitchen table.
Did you check and see if it had any ammunition in it?
Yeah, that was the first and foremost thing that I did, and I noticed that all of the ammunition in the firearm was live. It had not been shot.
Did you find any spent shell casings?
I did. I found 4 of them accompanied with the firearm in the bag.
In the bag?
Yes, sir.
Did you seize that firearm?
I did. Yes, sir.
And where is that firearm currently?
It was turned into the Jackson County Sheriff's Office pending as evidence.
All right. So after you seized the firearm, did you go ask her or did you go and talk to her again?
I did.
What did you ask her?
I had to catch her attention. I believe she was on a bit of a tangent with the other deputies, but I asked her about the spent casings that were in the bag, and again, if she had reloaded the ammunition, and if those were the spent casings she retrieved from the revolver.
And what did she tell you?
Again, it was answers, I believe she said 2 or 4 times, but she wasn't 100% sure if all of the rounds were used in that incident or whether or not she had reloaded the firearm.
As you were walking to her, did you have to walk through her front yard or her front porch?
I did.
As you were doing that, did you see anything in the yard?
I did. I observed a fresh, empty bottle that would be consistent as being an empty bottle of alcohol.
Do you remember what kind of alcohol it was?
It appeared to be a wine bottle.
A wine bottle?
Yes, sir.
So, question her a little bit more. Did you collect any statements from anyone else?
There was another lady in the house. I did speak to her and obtained a statement from her. Yes, sir.
And what was her name?
I believe it was Miss Bassford.
And if you need to refer to your report, you can do.
Christy Joe Bassford with a date of birth of 2/5/1978.
All right. So as you were speaking to her, did she show you around Ms. Pravat's residence?
Just a second, I'm sorry. Objection?
Objection, I guess.
Let's get you to approach. I'm not sure what context is.
That's approach number 8,242 for this trial. Wahoo, you can correct me if I'm wrong, but I'm pretty sure I'm close with that number. Happy afternoon or morning or whatever it is, wherever you are. Good to have you here at TCF Live. Obviously, our 4th hour overtime where we normally do more like discussion and commentary and maybe some news, court-related stuff that we don't normally see in the first 3 hours has been superseded with this trial. There's a very good chance we're going to go into double overtime here because I'll stick with it at least until their lunch break.
Mr. Mitchell, whenever you're ready.
Thank you, Your Honor. So as you were speaking to Ms. Bassford, did she show you around the house?
She did.
Did she show you to the back porch?
She did.
And when you got to the back porch, what did you notice about it?
It was very dark. I could observe the trailer belonging to the complainant on the other side of the lot. It was pretty obvious. Its porch light was on. However, Ms. Pravat's light was not on. And I had to use a flashlight in order to canvass the area looking for other evidence.
So Ms. Pravat's back porch light was not on.
Correct.
Was it working?
I didn't. Actually, I believe I can't recall.
Okay, you can't recall. But you took a flashlight to look out the back porch, correct?
I did.
And as you did that, were you able to see Miss Nichols's trailer back there?
I could.
How far away do you think her trailer was?
Rough estimate, I would say approximately 100 yards.
100 yards?
Yes, sir.
So after you collect a statement from Miss Bassford, did you attempt to collect a statement from Miss Ashley Nichols?
I did. Me and Deputy Grover relocated to her residence.
You said relocated to her residence. How did you get to her residence?
Using the driveway in a patrol vehicle.
Is that driveway the only way in and out?
That's what I was told by Ms. Bassford when I spoke to her, and that's what it appeared. We didn't see any other way in or out.
This driveway in question, how would you describe its condition?
Unkept, unpleasant.
Unpleasant?
Yes, sir.
And is it one that you can navigate at a fast rate of speed?
You probably could, but you're going to invest in a lot of suspension work on your vehicle.
So you're saying
no,
it could
you would
damage
not.
your vehicle?
Yeah, you would not want to drive down that driveway quickly. No, sir.
Okay. So did you make your way to Miss Nichols's residence?
I did.
And did you collect a statement from Miss Nichols?
I did.
After you collected the statement from Miss Nichols, did you have any other interactions with Miss Pravat?
We went back after we spoke with Miss Nichols. It was determined that Miss Pravat would be placed under arrest. Deputy Grover and I relocated, and that's when Sergeant Birch was attempting to get Miss Pravat into the back of the vehicle.
Was Sergeant Birch with you initially?
I don't believe he was there initially. He showed up about halfway through the investigation, and he was the one who did the transport to the county jail.
Okay, so you didn't transport Miss Pravat.
No, sir.
So once she was placed in the back of Sergeant Birch's vehicle, that was the last interaction you had with Miss Pravat that night?
No, sir. Due to her behavior after being placed under arrest in the back of a vehicle, Deputy Grover and I went to the county jail with Sergeant Birch to ensure that nothing out of the way happened.
You said due to her behavior. What do you mean by that?
After being placed under arrest, she became extremely erratic, borderline uncooperative, but she just was cussing, screaming, not wanting to initially cooperate with Sergeant Birch's request.
I gotcha. And after she was basically given to the county jail, did that finally conclude?
That was the conclusion of my interaction that night. Yes, sir.
And did that conclude your investigation on that night?
It did.
And finally, well, actually, no, not finally. And was your interaction post Miranda with Miss Pravat captured on your body worn camera?
It is. Yes, sir.
And may I approach the witness?
Yes, sir.
Deputy Swift, I'm showing you what has been marked as State's Exhibit B. Do you recognize what I'm showing you?
I do.
And what is it that I'm showing you?
That is a DVD drive that contains my body worn camera footage.
And have you had a chance to review the contents of this DVD?
I have.
And do the contents accurately and fairly depict what happened on November 18th, 2025?
It does, yes, sir.
And does it accurately and fairly depict your interaction with Ms. Pravat on that night?
It does.
Your Honor, this time the state will move to introduce State's Exhibit B to evidence.
Mr. McDaniel.
And
Admitted evidence of State's Exhibit B. Do we have, you have A? You have it in your possession? Okay.
And state is requesting permission to publish.
Granted. Has this one been limited also?
Yes.
You're requesting that instruction again?
Just for the
McDaniel.
record, yes.
Similar to the same instruction as last time, members of the jury, you're about to view and listen to a video and audio recording. I'm instructing you that it has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that it's been edited should not concern you in any way and must not impact the way you view and listen to and consider this evidence.
Just a moment, Your Honor.
Ms. Jane, you have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer before any questioning and to have a lawyer present during questioning if you wish. If you cannot afford a lawyer, one will be appointed for you at no cost before any questioning if you wish. If you decide to answer questions now without a lawyer present, you'll still have the right to stop answering at any time. You also have the right to request a lawyer at any time. You understand this, right?
Yes, sir.
Were you willing to answer the question for me?
Oh, yes, sir. I sure will.
What did you shoot at? Where'd you shoot the gun?
In the air.
Okay.
You just pointed it straight up in there.
In there. Because you know what? She come by here, she was hollering, I'm gonna kick your ass, bitch. I'm gonna get you, bitch. The other day she come down here and I'm 64 years old. She's 30-something. And she tried to jump on me then, but I had a stick by that goddamn door. And I took that stick and I hit her with it.
Okay.
And I told her.
Okay, we're not worried about the other day.
Where's the firearm that you used to shoot?
My 38.
Where's it at?
I got it in here on the table.
Have you reloaded it yet?
No.
Okay, so can I go in there and get that gun?
Yeah. No, I might have.
Wait
It
for the
had,
search
seemed like I shot twice. I shot twice in the air. I didn't
You
mean
have
to
gloves
shoot
on
her, but I don't want her to goddamn come down here and think she's gonna jump on me. She would have hurt me. If I didn't know how to defend myself, she would have hurt me.
Okay. Well, you
She
can
said,
understand
I'm
where we're
gonna kill
coming
you. I
from.
wish you're dead, bitch.
And was that
I'm gonna
tonight?
kill. Oh, she was just hollering out of that goddamn truck. I'm coming down there. That's why he says, no, stay here. No, I'm going to kill that bitch. I'm going to kill that.
And that was tonight?
That was tonight. And I got my goddamn gun. I said, and I locked all 3 of these doors. I said, you come in my goddamn house, you're fucked. Because if you come in here and try to hurt me, like you done the other day, I will fucking shoot you. And that's exactly what I told her, and that's what I mean.
And that's what you said tonight?
That's it. I said, you come in. I said, you come down here and come in my goddamn house and try to hurt me. You better watch it, girl. You better stay at your goddamn house and act like you got some sense. But no, she's a big badass. She's a bullet. She's done fucked, I don't know how many, she's done got 2 or 3 things. She's on probation now for goddamn anger management. Her ex-girlfriend and 2 or 3 other ones got trespassing once because they're scared of her. I ain't scared of her. I said, gee, bitch, I'm 64 years old. When she come down here the other day, she says, you bitch, I hope you die. I hope you die in your sleep. Motherfucker, you're a piece of shit. I hope you die. And she's out there hollering at me and doing all kind of shit. And then she tried to goddamn, she was throwing her hands at me. And I was going in the house. And I had my goddamn, I always had me a stick. I try to keep something everywhere. So you don't never know if somebody's going to try to goddamn jump on you.
Right.
And here. And then I popped her right in the face with that goddamn stick. I said, bitch, you better get away from me. And then that's when they went down there and said, do I want to press any charges? I said, that's my niece. I said, they got to get out of this trailer. I'm sick of them, tired of them, and I ain't fucking with them no more.
All right.
And that's what I meant.
This lady that was sitting there. So once again, you're fine with me going in there and getting that gun? I can go in your house and get that gun?
You can do anything here, honey. I ain't got nothing in this house.
Well,
you can ask anybody that's ever been here.
You said it's on the kitchen table?
Yeah.
But if you could just hang out with my partner here, I'm going to run inside and grab it, okay?
Deputy Swift, right quick, how many bullets did that 38 revolver hold based on what you have observed?
I believe it was 5.
It was a 5-shooter?
I believe it was.
Barbara,
It was
thank you
your
for the
testimony
$5.
that you found the spent casings at the bottom of that bag, correct?
Yes, sir.
And all those bullets that we just saw were live?
Yes, sir. So this is the bag that was in the kitchen table with the 38 in there. So there's 4 spent casings in here. Is that what you just took out of the gun after shooting? None of the casings in that revolver were spent.
Was there out there by that door? It was like 2 or 3 times. I didn't shoot at the fucking goddamn car. Her. I wasn't gonna kill that fucking woman. She goddamn. I don't want to kill her. I just want her to fucking leave me alone. I come in the house and lock my goddamn doors. So you know why? She's fucking stupid.
I get it.
She's done jumped on I don't know how many people. She look at her fucking record. She's on probation. She's got all kind of shit. And the other day she came over here and she goddamn kept swinging hands at me.
Yeah.
Ma'am. Miss Jan.
I understand.
Listen, we're concerned with what happened tonight, not what happened last Wednesday, not what happened last Monday. We're dealing with what happened tonight, okay? I need to know, there's 4 spent casings in here. This is a revolver. It's not like a regular pistol. The casings don't just fly out of the gun. Did you take these 4 bullets, these 4 casings out of the gun after you shot it? Because there's no bullets in that gun that were shot. There's 4 spent casings in here.
It might have been 4, I ain't sure.
Did you take them out or did you leave them?
When did
No,
you?
let's go in here and look. Come on, y'all come on.
Sure.
My damn 7 million, let's go on and look. I think that gun should be.
We got it.
Oh, I know one thing, I always believe in this stuff, that's my idea. That's the type. I don't do nothing.
I'm gonna this. I'll do you one better. I'll move to the front, okay?
I ain't never been in trouble. I try to stay out of trouble. And that piece of shit down there is one that's goddamn always starting shit.
Alright,
And I'm not gonna scare that whore.
Listen, for us to be able to conduct our investigation, I need you to calm down, listen to us.
Deputy Swift, I'm gonna pause it right quick. What was Deputy Grover doing right there with Ms. Pravat?
He was moving her handcuffs to the front from the back.
Why was he doing that?
I believe Deputy Grover had informed me that Miss Pravat was complaining of her shoulder pain. Of course, at that point, she was still being cooperative and she was not yet under arrest. She was still only detained. So it was just courteous to move her handcuffs to the front.
We don't need all the extra. Thank you, sir. Thank you, 3 fingers. All right. Let's go over here in front of Deputy Swift and answer this.
Okay, so this is the bag that the gun was in, right? So the gun's in the car. It's locked up. Okay. So there was these casings in the bottom of this bag. Were these the ones that you shot off tonight? Where would the bullet casings?
How many bullets was left in that gun?
It's not like a normal gun like we carry. It's a revolver. You can shoot it 6 times and all 6 bullets are still going to be in your cylinder. You had to manually take those bullets out and put new ones in.
Well, how many bullets do I have in there that was live?
All of them. So you reloaded it.
I must have took them out because that's when she started hollering and said she was gonna come out here and kill me. Okay.
Do you remember what you did with those bullets that you shot?
Is that in there?
Because there's a couple in here. I think there was 4 in here that's been shot.
Yeah, they're right there. 'Cause I didn't try to hide them or nothing. I ain't done nothing but fucking hide nothing from any of y'all.
So there's 4 of them in
I
here.
ain't never been in goddamn trouble.
Understand?
Okay, we'll just, okay.
That little bitch thinks she's gonna beat up me and come in my house. She ain't doing it.
Hey, your dog wanna bite us?
No,
Okay.
she ain't gonna do shit.
Okay.
It's trying to do right.
Understand? Well, that's what we're trying to figure out, okay?
I ain't never been in trouble.
We're gonna finish talking with you, we're gonna talk with her, we're gonna come up with the best case scenario, okay?
Deputy Swift, I think final question for you is Jan Pravat the woman you made contact with on November 18th in this courtroom today?
Yes, sir.
And can you please point her out and identify her by an article of clothing?
Yes, ma'am. She's wearing this red and black plaid clothing right here.
All right. We'll tender the witness.
Thank you, Mr. Mitchell. Mr. McDaniel. Thank you. Questions?
So Ms. Burch, she was being pretty cooperative. Would that be accurate to say? That's Deputy Swift, I'm sorry.
I apologize. Did you ask if she was cooperative?
Yeah, she was being very cooperative.
Yes, sir.
Yeah. I mean, state tried to make it out to be like she was trying to hide. Does it seem like she was more confused than trying to hide something? I mean, because she's like, go get the gun. It's right there. I mean, it didn't seem to me anything that she was just confused.
Personally, I believe that would be an indicator of the impairment, but yes, I understand.
Okay. And as far as impairment, I think she probably was drinking some. I'm not saying she's not, but look at her eyes right now. All those descriptions you put, she has right now. Would that be accurate to say?
Red, yeah, yes, sir.
And did you do any DUI testing?
I have never done DUI field sobriety exercises on a standard call for service.
Okay. Is it illegal to drink alcohol and possess a gun, or shoot a gun?
It's illegal to use alcohol and shoot a gun, yes, sir.
Okay. Thank you. I appreciate that, Deputy. And that's what your understanding is?
Yes, sir.
Okay. She went on a lot about, did y'all do any investigation about, the threat that she perceived to have? Did y'all do any kind of investigation on that?
I did.
And what did you come to with your investigation with that perceived threat?
Miss Nichols, she claimed, was threatening her from her vehicle. She never left the vehicle, and I did not believe that the crime of assault had occurred that night. Miss Nichols never left the car, never made an advancement towards Miss Pravat. She was in a driveway that she uses every single day to get to her own property. So I don't believe that an assault was committed that night.
But the other woman that was there, did you question her and ask her what she saw?
I did. Are you talking about Miss Bassford?
Miss Bassford.
Yes, sir.
When you asked her about the drinking, you did a lot about that. I don't recall you asking her about that particular issue.
Because she openly, she said that Miss Pravat had been drinking, and she said that she gets that way, and then stated that Miss Pravat was more upset about an incident that happened a week prior than anything that had occurred that night.
Okay. And in your experience, something that happened a week prior had nothing to do with that night. Is that correct? That's what I caught from the video.
Practically, yes, sir.
Okay. I don't have any questions. Any more questions?
Thank you, Mr. McDaniel. Mr. Mitchell, any redirect?
No further questions, Your Honor.
All right, may this witness be released?
Yes, Your Honor.
Mr. McDaniel?
Yes, Your Honor.
So thank you very much, Deputy Swift. That concludes your time and testimony here today. You are released from your subpoena. You're free to leave, or you're free to watch the remainder of the trial if you wish. Thank you.
Thank you, Your Honor.
Yes, sir. Any other witnesses, Mr. Mitchell?
No further witnesses at this time. The state will rest at this time.
Let me talk to you outside bar and we'll get together a plan for a lunch break and be back with you in just a second.
Okay, I'm going to assume they're going to take a break here, but we'll hang with it until we know for certain. So the plan will be, if I didn't have other things to do and if we didn't have sidebar tonight, I'd just, I'd come back after their lunch break, but that's not overly practical. So what we'll do, assuming they are taking a break here, is we'll pick this back up tomorrow morning. Fridays are littered with landlord-tenant and not always the greatest of hearings anyways. So I'm going to make sure that this gets recorded during the day today, and we'll pick it up tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. But again, we'll hang tight here until we're certain that they're done for now. But I hope you all had fun with this. I did, and I'm curious to see how it ends. It is just pure Florida, isn't it? Hate to have that that image of Florida. Florida's got some things going for it, but this fits. Michael says this was fantastic. Great granny. Good Dan, because I have some things to do today too. Yeah, there are things to do for sure. I probably should pay some attention to some of the other ways that we make money here at the TCF bunker. All right, he's back.
All right, ladies and gentlemen, I want to give you an hour, everyone an hour for lunch. And so that the sooner we get started after lunch, the sooner we get over with and get the case in your hands later this afternoon. So what we're going to do is we're going to go ahead and recess for our lunch break. It's 11:57 by this clock right here. Clock on the wall shows about the same thing. We're going to start back at 1 o'clock. 1 o'clock p.m. sharp. I need you outside in the hallway on those benches by 1 o'clock. And then once all 7 of you are here, we'll get you in here and we're going to try to start testimony. And whatever's the next step is, whether it's defense witnesses or not, we'll hear that starting at 1 o'clock. You may have any questions? All right, I'm going to remind you of the previous instructions I've given you. If anyone tries to talk to you about the case, stop them, let the bailiff know that's happened. Otherwise, no one should be talking to you about the case, and don't talk about the case amongst yourselves even until the completion of all the testimony. So we're going to be in recess. Does anybody have anything in the jury room, any kind of belongings or anything? No? All right. We will see you at 1 o'clock sharp. Court's in recess. You can leave your notes in your chair. They'll be untouched. They'll stay right where they're at.
Okay, friends, it's about 12:10, 12:11 local time where Judge Mercer is. So, yeah, we're not that far on the Wayback Machine, so there'd be a huge break anyway. So we'll pick it up tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, right here on the live show, and we'll run it through and see where it goes. And it'll be fun, so be sure you're here bright and early, because that'll, unless there's something crazy going on that I've got to show right in that moment, this is where we'll start the day tomorrow. So be sure to be there for that. And please join us for Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. Tonight's Sidebar is going to begin, at least, with that 5 DUI guy that we saw in Judge Stevens' court. And actually, in about 50 minutes, that goes live on this channel as a separate video. So your homework assignment, if you don't know what case that we're talking about, go watch that video when it posts in 50 minutes, because that will be that whole sentencing hearing, and that will bring you up to speed for the basis for tonight's Sidebar. Again, we're right here on this channel, 8 p.m. Eastern, 5 Pacific. So I hope you had fun. I did too. Look forward to seeing you all tonight and then again tomorrow. In the meantime, go have yourselves a great day. Take care. God bless.